Yes, what was the last? I think we have discussed till Article 19. Okay. What is the Article 19? Yes, freedom of speech and expression. So what all rights are implicit in it? First of all, what are the explicit rights? There are 6 rights within the Article 19. Yes, what are the 6 rights? Freedom of speech and expression, freedom of assembly, okay, peaceful assembly, freedom of association, freedom of movement, freedom of settlement, and freedom of profession. Okay, so these are the 6 rights. And there are so many reasonable restrictions also. Okay, reasonable restrictions. For each one there is a different reasonable restriction. For freedom of speech and expression, there are 8 restrictions. Okay, then for the freedom of assembly, yes, for freedom of assembly there are 3. What are 3? That is sovereignty and integrity, public order, and only 2 moralities. Okay, so except morality, that is also for the next one. Okay, that is for the association. Then for the freedom of movement and settlement, there are 2. Okay, that is, yes, public interest and scheduled tribe. Okay, in the interest of scheduled tribe. And for the profession that state can exclude. Okay, state can exclude, that is, state can have a monopoly. Okay, and other than that, there can be a qualification for the specific profession. Okay, this much we have done. So let's start with the, this was the second class of rights, that is right of freedom. Right of freedom, these are the second type of rights. So within the right to freedom, there are 4 rights. That is Article 19, which we have already done. Now we have to do Article 20, then Article 21, Article 21A, and Article 22. Article 19 is speech and expression. Yes, Article 20 deals with, okay, freedom with respect to conviction of offense. Conviction of offense. Then this is with respect to life and liberty. This is 21 is with respect to free and compulsory education. And 22 is with respect to freedom or rights with respect to arrest and detention. Arrest and detention. So these are the rights. So we have discussed the 9. Now let's take the Article 20. Okay. Article 20. And this is a freedom with respect to, that is, conviction of offense. Conviction of offense. Now see, the thing is that whenever this right is with respect to protection of arbitrary punishment. Okay, yesterday we have discussed something called as, I'll come to this article later on, something called as rule of law. So what is the meaning of rule of law? That is, everything will be determined as per the law or as per the constitution. So nothing, so opposite of this is, nothing will be based as per the, yes, human being, or as per the persons, or as per the arbitrariness, whims and fancies of the person who is holding the power. So his whims and fancies will not work. What is written in the law, that will work. So in fact, precisely whenever you punish someone, that punishment also has to be based upon the law. You cannot arbitrarily punish someone. So this particular aspect is trying to protect the individual from the arbitrary punishment. Arbitrary punishment, so that's the protection is given. Now when we discuss about this protection with respect to conviction, conviction means when he's going through the trial and he has been convicted and then jailed or given the punishment or the fine, etc. So with regard to conviction, there are 3 freedoms which are available, okay, within the Article 20. First freedom is, there is no ex post facto law. There is no, I'll explain first, just let me write. There is no ex post facto law or legislation. Second is no double jeopardy. No double jeopardy. And third is no self-incrimination. No self-incrimination. So these are the three different aspects. No ex post facto law, okay, no double jeopardy, and no self-incrimination. Now let us discuss this first. What is no ex post facto law? Say for example, an individual commits a crime, okay. Now this crime, if he commits the crime today, there has to be a certain law that he should break the law. Crime is about breaking the law. So he can be punished for the breaking of the law and not otherwise. If say for example there is no law today and he has done some crime, say for example in India today there is a no law with respect to some of the crime. So 10 years down the line or 10 days down the line, if you make the law and then retrospectively apply the law, that will not apply, okay. So the condition here is the law has to be broken, and second is the amount of punishment that is given should be in proportionate to what is mentioned in the law. So there are two aspects. That is no ex post facto means there will not be a retrospective, okay, implementation of the law in order to punish someone. Are you understanding this fact? In fact, there are two things. Not only he cannot be punished, but he cannot, his punishment also cannot be increased. Okay, there is also a proportionate theory, or say today law says that for this particular crime you can go into the jail for 2 years. Okay, 5 years down the line for the same act, the statutes say that you can go into the jail for 5 years. So that cannot be retrospectively applied because the day on which the crime was committed, it was only 2 years. Okay, so there is no retrospective law. That is the point here. No ex post facto. Ex post facto मतलब वापस जाके उसका implementation नहीं होगा. I hope everybody has got this point. Yes, anybody who has not understood this aspect? All of you? Okay. Second, now there is no double jeopardy. There is no double jeopardy. What does it mean? That if you have been punished for the crime once, so for the same crime you cannot be punished twice. Okay, so this is also proportionate theory of justice. That is your crime, and related with that crime, if you have already punished, so you cannot commit that particular offense again and again. Okay, this is different from क्या बोलते हैं, frequent offender or repeated offender. Okay, then the crime itself is happening second time. Are you understanding? That should not be confused with the yes कि 2 बार चोर ने चोरी कर दी, मतलब जेल के बाहर आके फिर से. तो ऐसा नहीं है कि there is no double jeopardy. Okay, so obviously that's as simple as that. He will not be punished for the same crime twice. There is no self-incrimination. Self-incrimination, say for example, person before conviction, he is called as there are allegations on him. If there are allegations, these are only allegations, and then when he will be convicted finally. So at the time of allegation, he will not be forced to act as a witness against his own crime. Okay, so it means that he will not tell to the court, okay, and he will not be forced to say that he will act as a witness for himself. Okay, this is because although this is generally we say that practice is not followed, because when you are in the police custody, we understand that police in fact go to any extent in order to force you. But ideally there should not be any self-incrimination. He should not act as a witness for himself. Okay, so these are the some of the freedom. We will see now the details, because there are certain exceptions also for each. Now here there cannot be a retrospective law. Say for example this is an act, and this is an act of crime. This is act of crime, and this is a law in future. So this future law will not apply for the past crime. This act, इसमें जहाँ पे इस दिन जो law होगा वही apply होगा. But there are exceptions. Okay, there are exceptions to this. Yes, what is the exception? This is applied only in case of criminal law. So it means that for the civil law there can be retrospective effect. Okay, so in case of, so this freedom individual will get for the criminal law, okay, or criminal related matters, and it will not be for the civil matters. such as say for example taxation and etc. So that's the thing you should yes understand. That is, there will not be a, yes, for the civilian law there can be a retrospective effect. That's the most important part. In case of double jeopardy, okay, yes, there will not be a punishment for the same crime, repeated punishment for same crime. Two bar punishment nahi hogi or more than one nahi hogi. But see, the thing is that what court decides, courts or semi-court decide, that is your punishment. But there is a possibility that you are working in a government, so there can be an administrative or departmental inquiry. Okay, so for example, you are working in a department or in administrative unit or departmental unit can go for inquiring your crime. So you cannot say that ki court already there is an inquiry has happened, so there cannot be a double jeopardy. Double jeopardy, this crime has to be, that is whatever the punishment, it should come from the court. That is considered. Court will not give the punishment twice. So departmental inquiry will not be count as a first punishment. Okay, punishment will be this. Okay, whatever the court will say. Points are clear or not? Okay, so the victim might say that I have read that there is no double jeopardy, department has already taken an action against me, so why you are putting me in the jail? So that's not the case. Okay, departmental and administrative inquiries will not be considered as a first crime. The third thing is with regard to self-incrimination. What we have said in case of self-incrimination, that an individual will not be act as a witness for himself, will not be witness for himself. But there are certain things, okay, whenever you commit the crime, you require to give the sample. Okay, say for example, you require to give the blood sample, which blood sample might, okay, after the investigation, go against your favor. And what has happened? Your sample has become a witness against you. Okay, but that you have to do. Okay, विटनेस मतलब आपको जो ओरल एविडेंसेस है, मटेरियल एविडेंसेस, उसके लिए फोर्स नहीं किया जाएगा. बट द थिंग इज दैट देयर आर सर्टेन कंपल्सरी प्रोसीजर्स दैट यू रिक्वायर टू डू in order to give or help the judicial process. So in that context, what all can come in that context? That DNA sample, okay, blood sample, semen sample, exhibition of the body. Okay, so whatever the police inquiry ke liye, in order to see that how the crime has conducted and etc. Those things, but they will not force you that you only has committed and etc. And then you can come forward and say that I have committed my crime. Okay. Have you understood? So what is protected, but what is permissible? Okay. In fact, there are lot many things here, and that's a part of the means. Actually, there are say brain mapping. You must have heard of narco analysis. Okay. So there has been a question mark on these particular tests, brain mapping and narco analysis, because in case of a narco and brain, you are actually infringing upon the no self-incrimination. Because in case of a narco and this brain mapping, the person is speaking out and he himself is acting as a evidences for or witness for himself. So the Supreme Court has questioned in number of times. There are also issues with regard to the sensitivity and specificity of the cases, that not it is not a factually established that whatever you say in brain mapping has to be correct one. Okay, that isn't regarding the whether it is a specific or sensitivity of the test or not. That is more of a technical side. But should we go at all for any such is a matter of Article this 20. Understood? So this is about the Article 20, that is related with the conviction. Conviction, no ex post facto, there will not be a retrospective effect, no double jeopardy, and he will not act as a witness for himself. Understood? So that's it for this. Now let's move to the Article 21. Yes, freedom of life and liberty. The most important, I would say, and again, lot of development has happened with respect to Article 21. So, Article 21, that is state cannot take the life and liberty. Okay, state cannot take up the life and liberty of an individual, liberty of person, Except. What is except? What is except? Yes, except procedure established by law. Okay, so lot many things we have to discuss. Otherwise, if you see that this much is only the, there is no clause, there is nothing. Okay, this is the सबसे narrow और छोटा है, लेकिन now it has been सबसे बड़ा, मतलब बहुत expand हो चुका है इसमें. Okay, so if you go by this logic, life and liberty of a person except by the procedure. So life and liberty is guaranteed, but it is not absolute. Okay, we have discussed yesterday that fundamental rights are not absolute. Some of the fundamental, what are all restriction in some of the fundamental rights within the article, they have written what is the restriction. Say for example, in case of article 19, just now we have discussed, there are lot many reasonable restrictions have been applied there and there itself. Some of the restriction, something like this has been written, except by procedure by law. So law will give effect what are the restrictions that can be imposed. So some of the restrictions are imposed by the law also, and some restrictions we have discussed through the Supreme Court verdict. Different verdicts also give the interpretation, narrow interpretation to the world, and therefore they will say that this is permissible and this is not permissible. Something like one example, freedom to life and liberty. Life does not mean freedom to kill yourself, or freedom for death, or freedom for suicide. Okay, so this kind of the interpretation, so Supreme Court interpretation. So if the question is asked that reasonable restriction can be put by Constitution itself, law itself, so court's verdict, so all are correct. Okay, there can be different ways through which it can be curtailed. Okay, so here we are going to see that is interpretation of the word life and liberty. In fact, here there are two parts. This part, that is what does it mean by the procedure established by law, and then we'll come to the what is the ambit and the scope of word life and liberty. What does it include in the life and liberty? So first we will see that if at all this freedom has to be curtailed, okay, so there has to be, somebody should make the law, and that law should have a, again there will be a judicial review for it. So for this interpretation we are going, now before even going into this thing, there are two concepts here. Okay, one is the procedure established by law. Procedure established by law. Okay, something like what has been mentioned here. And there is a due process of law. Due process of law. These two terms have different connotation. Procedure established by law is different from, yes, this is established by law. Now, this is what is the meaning of this and this? Yesterday we have seen there is judicial review. Judicial review for all the laws that are passed, not only laws, orders, ordinances, rules, notifications we have discussed. Now, how the judicial review is done on the law that has been passed? There can be a two basis. One basis is simple. Okay, that is they will only see the procedure. They will only see the procedure. Okay, so we are going to start tomorrow Parliament. So we will see that there is a procedure. Okay, 3-stage procedure is there. So procedure established by law. In this case, judiciary will review, okay, constitutional validity of law by checking whether the procedure followed is correct or not. Okay, they will not see what is the intention of the lawmaker. They will not see the substantive aspect of the law, whether law at first instance should have been there or should not have been there. They will not look into it. They will simply say that whether the parliament has followed the 3-stage procedure or not. If there is any mistake, so obviously they will say that this is absolutely, this can be curtailed. So parliamentarian only have to ensure that procedure should be fine. That is an US. This is this is followed in UK or Britain. Okay, this is followed in Britain. This is one of the reasons why we generally call Britain Parliament is the strongest parliament, because as such there is no जुडिशियल रिव्यू, क्या जुडिशियल रिव्यू रहेगा? स्टेजेस तो फॉलो ही होगी ऑब्वियसली, टेक्निकलिटी एनीबडी विल मेंटेन. So it means that whatever the law which will be followed, the UK judges don't have lot of scope in order to curtail the law. They have to only check the procedure. That's why it is called as the Parliament of the UK is the strongest in the world. Okay, what happens in case of America? America, it's not the procedure established by law, it is a due process of law. So in case of due process of law, the principle applied is natural justice. Okay, your law, whether it is, yes, whether the law is constitutional validity can be checked by applying the principle, not just the procedure but the natural justice. In case of natural justice, they are going to see the intention behind the law. Okay, and they will check whether the law is fair, just and reasonable. Whether the law is fair, just and reasonable. These three words are important whenever we describe something as a natural justice, so we have to use this term. Okay, fair, just and reasonable. Now what they are doing is they are also going into the intentions, okay, or the minds of lawmaker, not just the procedure, that whether such law is morally, ethically correct, it should, if it is curtailing, whether they should curtail the freedom or not. So the ambit of judicial review in case of America is very, very large, and therefore we see that judiciary is very strong in case of America, whereas the parliament is very strong in case of UK. Okay, so this is the concept of procedure established by law and the due process of law. Now in India we have written this, okay, inspired from the UK or the Britain model. So initially when we wrote the constitution this way, and the word used is this. But Supreme Court has given the different interpretation for this word. So in a background we will keep this, and now we will start what the Supreme Court has to say about the interpretation. Okay. Now the first case came in 1950 itself, that is a Golaknath case. Okay. No, Golaknath nahi, Gopalan case. Yeah. हाँ, A.K. Gopalan case. A.K. Gopalan case, 1950. Now here what they have said, this procedure established by law is something like a Britain. That is a narrow interpretation. So in bracket, you can just for your remembering, like, narrow interpretation. There was a narrow interpretation, and they say that, yes, that is a procedure established by law is merely the, that is Supreme Court or the judiciary will only see the procedural aspect. Say Lakshmikant has written something called as Gopalan case gives that is a power to judicial review for the executive arbitrariness and not the legislative arbitrariness. What does it mean? Say for example, law is passed. Law pass karne ke baad executive, how they are implementing the law. They can trespass the law and can go beyond the ambit of the law. So if they are going beyond the ambit of the law, Supreme Court can come and say that you are crossing the ambit of the law. So arbitrariness of executive is stopped. Are you understanding? But for law in itself, they cannot go and say that you are going beyond the ambit. They will only see the procedure. So in case of Gopalan case, what has been ensured is the arbitrary action taken by the executive, and not, what is not ensured is arbitrary action taken by lawmakers. It will only see the procedure. Okay, that is a very limited one. Understood this part? Okay, so this was a Gopalan case, very narrow interpretation, and interpretation what is given in case of a UK. There are other interpretation also that we will see that, I'll keep that aspect later on. Second is, yes, there has been change. Which case? Main का नहीं है वो, मने का है. हाँ, Lakshmikant also has given the wrong. Okay, actually इनकी शादी हुई थी तो, yes, I hope everybody knows the story. तो Mrs. Indira Gandhi said that Apsara, Ramba, Menka will not be in laws. तो Menka का Maneka कर दिया उन्होंने. ठीक है? Maneka Gandhi case, anyways. So in this case, they have changed what has been interpreted. Okay, so narrow interpretation नहीं है यहाँ पे, broad interpretation. Supreme Court has gone for the broad interpretation. They have not changed the word. They have simply interpreted procedure established by law in India means or also includes due process of law. Due process of law. Even if the word procedure established by law is there, it means that there is a due process. There is a due process means, just now we have seen that judiciary can apply the principle of natural justice. Okay, that is, they are going to see whether the law is a just, fair and reasonable. In terms of executive and legislature, now they can check the arbitrariness of both executive as well as the lawmakers. I hope the point is clear now. Okay, so this is a broader interpretation, and this is one of the reasons why we see that the judiciary becoming again more powerful. Yesterday there was a one case, that is a Keshwananda Bharati, where they have increased their ambit by doctrine of basic structure, and basic structure has not been defined. So this is one of the reason where now the due process has expanded the ambit and the scope of judicial review in India. Okay, apart from what rest of the things. So due process, so this is an interpretation for this word. So, but see, the thing is that although the due process we follow, the wording is still procedure established by law. Only the interpretation has become. So we haven't made an amendment to write this particular aspect. I hope point is clear. So this is about the two cases with regard to this aspect. So the judicial review has increased. Now come to this aspect of, that is state life and liberty. Again, we will use the two same cases. We will use the two same cases. In case of a Gopalan case, there was a narrow interpretation of the word life and liberty. Okay, narrow interpretation in a sense that they say that life and liberty is related with the existence of human beings. Okay, it is not having a very wider interpretation. It is about the like life and death, existence, mere existence, mere physical body से related जो चीजें हैं, that is about the life and liberty. Okay, but here Menka Gandhi case, they have given again the broader interpretation of life and liberty to an extent that in the life they have used that life is not like an existence like animal. Okay, animal are okay there like that. Human beings are not like an animal, just they can exist. There are so many things which are required to have a meaningful and a complete life. Okay, so they have gone for the interpretation life is not mere existence. Okay, it is not mere existence like animal existence. Okay, life means meaningful life, complete life, and anything that is required to make the life dignified. Okay, anything that is required to make, so life is not like animal existence, not like existence, but life includes the human dignified life, human dignity, that is a dignified life. Mere existence is not there, and anything that is required to make the life complete, ब्यूटीफुल भी है क्या, बताया था शायद, ओके देखो कुछ है तो, ओके, एंड वर्दी. Okay, these are the three words used, but that is not important. But yes, making the life complete, beautiful, and the worthy. Understood? हाँ, मतलब जो भी समझ रहे हो आप वो भी है, ठीक है? But the point is, there are so many things now. The scope has increased too much. Again, they have not defined that what we are calling. Okay, they are not coming into the. See, yesterday we have said that basic structure they have defined, but they haven't told that. These are the 3 points in basic structure, 5 points in basic structure. They keep on adding. In the same way, they also started adding what is a right to life. So over a period of time, we will keep on adding that is what is right to life. So from Menka Gandhi case to till date, the ambit of or the amplitude of life and liberty got increased. Okay, so it is not just the physical existence. Yes, what all ambit has increased from Menka Gandhi case till date. यस एक दो बताए. पहले तो लाइफ, डिग्निफाइड लाइफ, राइट टू डिग्निफाइड लाइफ. यस, दैट्स इट. Yes, how the ambit of right to life has increased. Right to clean environment. Yes, environment एक broadly याद रखो. Okay, environment. So इसमें clean environment, clean air, pollution free water. Yes. Then food, right to food, right to employment. Right to employment, right to privacy. Yes. What else? Yes, speedy justice. Speedy justice, fair trial. This become a fundamental rights and very wider interpretation. Okay, right against the bonded labor, etc. Okay, so it becomes a fashion now. Okay, Article 21 मतलब जो भी नहीं आ रहा है तो Article 21 में डाल दो. अभी LGBT rights they are saying that they are also infringing upon right to life. So what is there is no dignity. There is no dignity for the LGBT. In fact, they are not even recognized as citizens, because if you see by Article 15 and 16, 15 says that there will not be discrimination on the basis of sex. Okay, but the sex does not include sex orientation, and therefore there is a discrimination. So 14, 15, 14 also, equality before law, equal protection of law. So the sex between two consenting adults, if it is a hetero, that is not punishable. But if it is homosexual, then it is punishable. So the same class, even if there are adults, they are consenting adults, then also there is a discrimination. Anyways, so that's about the ambit. So is Article 21 mein two things you should remember. That is about the discussion on this, that is procedure established by law, and second is with respect to life and liberty, that earlier the scope was very narrow and the scope has gone increase. Earlier the interpretation of procedure established was narrow and this has gone increase. Understood? Now there are certain aspects important for the means. I will just very briefly in 5 minutes just highlight what are the controversies which are for the means basically. Okay, but if the questions come, you can able to at least write something about it. See, with respect to the life, now we are discussing what about the death. Does it include the right to death? Okay, so there are three things within the death part. First is whether the right to life also has a right to death or suicide. Okay, whether this is the first question. Second, euthanasia, that is mercy killing. And third is capital punishment. Okay, so these are the three controversies related with it. Understood? So now first, right to death or suicide. Now, see, the thing is that obviously, so the Supreme Court has cleared already that right to life does not include right to death. So you don't have a right to death. Also, now very recently, there has been decriminalization. Okay, that जो IPC section था, IPC section से ये remove कर दिया गया है. Attempt to suicide. Attempt to suicide is no more a crime. Now, since the crime has been removed, it does not mean you have got a right to commit the suicide. Are you understanding? Something which has been decriminalized does not give you a chance, it becomes your fundamental right now to go for the attempting suicide. Are you understanding? There is some neutral position, there is some positive position and negative position. From negative position to we have reached to the neutral position, but it does not give you the fundamental right. So even if it has been decriminalized, still right to life does not include right to death. Here also there was a case of Santhara or Salekha, क्या बोलते हैं उसको? Salekha. Santhara or Salekha. Yes, what is this Santhara and why we are discussing under this Article 21? Yes, Jain, they fast unto death. Now, after they feel that their life, productive life has ended and there is a fulfillment to the life, they are satisfied, and now they see that Okay, that is, they will go for the fast. The elder person, okay, elder person, 50, 60, whoever it is, he will think that I have lived my life to the fullest, and now from today onwards, I will stop taking the, yes, food. And whenever he will die, he will die. That is with respect to practice called as Santhara. Okay, Jain religion में ये practice होता है. Now there has been a filing of the case against the Santhara in Rajasthan High Court. Okay, petition was filed, and yes, the under that petition, what was wrong anyways? Why it has to be questioned at all? If that person is himself is going for it, why it has to be questioned? What was the petition was saying? Why it questioned? It is amount to suicide one. Abatement to suicide also, yes. There are property issues. So घर वालों को ऐसे ही मतलब will लिखने के बाद बोल दिया कि संथारा ले लो. Okay, so there was a misuse after the writing of the will obviously, will जब तक नहीं है तब तक संथारा नहीं होगा, ठीक है. Will होने के बाद they will push for the संथारा. Okay, yes, that is a misuse was happening. Second thing is you are somewhere obstructing the natural process, okay, natural process of the death. Yes, so because of this it has been challenged. What was the decision of Rajasthan High Court? Yes, Rajasthan High Court sustained, yes, they have said that Santhara should get end. This is not a correct practice because it infringes upon the right to life. They say that it also, like there is a lot of misuse also, and they say that it is not something called as essential religious practice. That if you stop the Santhara, Jain will lose its significance. Okay, so in a way they have said that such kind of the practice should not be carried out. Then there was a lot of hue and cry by the Jain community that it is again that classical of secularism and you enter into a particular religion, etc. The case is with the Supreme Court. What is the status now? It has put the stay. Okay, it has put the stay on the. So that's about the something very equated to suicide or for that matter the right to death. Okay, Yes, that's also not correct as per this article. Yes. इसीलिए स्टेट क्या करता है जिस दिन मतलब दे प्रोवाइड द मेडिकल हेल्प मतलब डॉक्टर जाके चेक करते हैं जैसे ही वो मतलब थोड़ा सा तबीयत खराब हो गई ब्लड प्रेशर तो उनको एडमिट किया जाता है या फिर उनको फिर सलाइन के थ्रू दे मेंटेन द वाइटल पैरामीटर्स ओके दे डोंट लेट द पर्सन डाई हाउ मेनी पीपल हैव रियली डाइड मतलब डूइंग द फास्ट अन टू दैट हाँ अरे मतलब वही इंडिपेंडेंस के पहले तो वो तो अलग ठीक है एनीवेज बट दैट्स नॉट परमिसिबल ऑब्वियसली euthanasia and mercy killing the situation has changed earlier was different here the case important is Aruna Shanbag case still Aruna Shanbag herself never got the euthanasia okay yes so because her friends Pinky करके नाम था उन्होंने कहा कि हमने इनको 30-40 साल रखा हुआ है so we will so that was a very emotive issue therefore the euthanasia was not granted to Aruna Shanbag but nonetheless Supreme no she has passed away but no array not for her let me finish it what it is no not she's died she was alive very much but the court has taken the opportunity of Aruna Shanbag case not to grant her euthanasia but here onwards we are saying that if such case will be there we will open the door for the euthanasia in India although she has not got the one okay she died because of the natural death okay not through the euthanasia she was do not be mistaken that way okay she herself was never got the euthanasia but through that case there was a Markande Kadju and these people were there so they have accepted that here onwards like something like a Vishakha guideline there was a no law Vishakha guideline 1998 for the sexual harassment at workplace it acted as a law for good 15 years only after the Delhi gang rape after the Justice Verma committee recommendation, there was a law. Now we have a law that is sexual harassment at workplace. But for more than a decade, we only use the Vishakha guidelines. In the same way, court has said that law has not been formed, okay, parliament, but till the time the law will be formed, okay, this guidelines will be used. So Aruna Shanbag case has opened what is known as a passive euthanasia, not active euthanasia. What is the difference between the two, passive euthanasia and active euthanasia? Yes, they will inject something, and in case of yes, in case of a passive euthanasia, they will withdraw the life support. Okay, life support, maybe the person is on the ventilator, so ventilator, he will be taken away from the ventilator, or there are certain life-saving drugs for the cardiac muscle contraction. Okay, they will stop injecting those drugs. So naturally, that is a withdrawal of support, which is somewhat what we can say that can be acceptable. Okay, and injectable is through the very active. So active has not been there. They have opened the door for the passive euthanasia, but there are three-stage procedure. It's not immediately. Three-stage procedure. First is the consent. Okay, consent can be given by the patient if he can be, but if there is a permanent vegetative state, okay, the person cannot give the consent, but relative can give the consent. Okay, so the kith and kin of the person or the next to the kin can give the consent. So either by the patient or by the yes, by the near and dear one. So that's the consent. Second is there will be a 3-member committee of doctors. Okay, and doctors is going to see whether the case is fit for euthanasia or not. It means that there can be an unscrupulous doctors and they might, yes, one doctor रहेगा तो वो मतलब प्रॉपर्टी के लिए यस उनको यूथेनेसिया देने लगवाएं, तो देयर कैन बी अ क्विड प्रो क्वो बिटवीन द सिंगल डॉक्टर एंड द फैमिली. In order to avoid, there is a multiplicity of the doctor, and 3 members doctors committee will be formed in order to say that yes, the case is fit. Fit मतलब क्या है? There is no possibility of going back into the active life. Whatsoever the medical advancement, there is no possibility that person can have the normal life. Okay, after that, High Court is going to take the decision. This opinion of the doctors will be placed in front of High Court. High Court, at least minimum 2 judges will be there, and these 2 judges will take the decision based upon the 3-member committee's opinion of the doctors. Okay, and finally the euthanasia. Again, may be asked, may not be asked, but just remember that way. Okay, and capital punishment, as of now, there is a capital punishment. Okay, there is a capital punishment, although there is a lot of debate about the yes, abolition of capital punishment. But yes, one important doctrine you can remember, that is a Bachchan Singh case में जो आया था, that is a rare of rarest doctrine. Okay, rarest of rare. So this doctrine has been reserved only for the rarest of rare cases. Would you like to take the discussion, or it's not required? Means के लिए लेना है या नहीं लेना है मतलब? हाँ? Okay. Prelims में ऐसा नहीं क्वेश्चन ना आएगा कि कैपिटल पनिशमेंट शुड बी अबॉलिश्ड 1 2 3 4. दैट्स सब्जेक्टिविटी. एनीवेज 5 मिनट्स लग जाएंगे. पॉइंट्स फॉर एबॉलिशन एंड पॉइंट्स अगेंस्ट. अगेंस्ट मतलब शुड इट मतलब कैपिटल पनिशमेंट शुड बी रिटेन्ड and capital punishment should be abolished. Yes, what is points for? Yes, one is the deterrence. That is the foremost thing, that those who want to retain, they say that it provides a deterrence. Yes, it provides a strong deterrence for those, okay, yes, not to commit the crime. Second is retributive aspect. Retributive means yes, that is a punishment aspect. That is, if there is a heinous crime, only death can matlab provide sort of a justice. Okay, something like a rape, dacoity, horrendous crime and whatnot. Matlab heinous crime hai, so only death can satisfy. Less than death is something you are not doing the justice, as for those who are supporter of it. Yes, anything else? Huh? Secretary of State, what is it?
Maintaining them in a prison.
Okay, fine. That way, maintaining the prison, that is one thing. Security बोल रहे हो आप? Okay. हाँ, there are 2 things basically. अब उनको कैपिटल पनिशमेंट नहीं दे रहे हो तो वो जेल में रहेंगे, तो उनकी सिक्योरिटी है, या फिर जेल तोड़ के बाहर निकलेंगे. There is always a threat There is always a threat to that they might come or something, like they can somebody will hijack the plane and then capital punishment नहीं रहेगा तो यही है. मतलब think of कसाब अभी है बाकी, okay, and somebody has hijacked the plane, then you have to मतलब minister will go and leave and etc etc so much. Pardon? Ah, yes, there are cases of breaking the jail also. These are the three important issues to retain the capital punishment. Yes. Now let us discuss about abolition of capital punishment. Yes, what are the points for abolition of capital punishment? How many of you wants to abolish the capital punishment? Yes. Please raise the hand. Only one, two. बहुत पढ़ना पड़ेगा फिर तो आपको, मतलब मेंटल को पढ़ना पड़ेगा बोल रहा हूँ. मतलब जस्ट बिकॉज आई हैव डिस्कस दिस, मे बी आई विल अगेन आस्क कि ये इधर के पॉइंट होने के बाद क्या होगा. ओके, फर्स्ट इज इट इज लाइक अ वेरी ड्रेकोनियन टू किल सम. लेट मी सिंपली पुट इट दिस वे. somebody has killed someone, you are calling it as a horrendous crime. He has killed someone, it's a horrendous crime. And then you are killing him and calling him justice. No, what I am saying is, somebody has killed, you are calling it, he has committed an horrendous crime. We should provide a justice because he has killed. And then we are killing him and calling it, now we have done the justice. There is also a second point here. There is also, it's not even that. When he commits the crime, it is his individual pathological mind which might have led into the commission of the crime. And here when you are killing, it's the so-called collective wisdom of the society is giving the capital punishment and calling it justice.
You are killing a criminal and the person, the criminal have
Yes, that point is there. But when we are saying that killing someone was a crime because he has led into the death, why you are calling is horrendous? Because there is a death of someone. Yes, these are the points. Just I am saying, I am just opening the topic. Yes, what are the more points? That's it. Yes. Yes, that's a very important aspect of justice. First of all, okay, let's go this way. Deterrence. There are no proof whatsoever. There are no proof. If you go into the NCBC record, National Crime Bureau records, number of capital punishment over last 10 years have increased, number of crime has gone double, triple and quadruple. Okay. So if there has to be deterrence, there should be a decrease in this. So there is no corroborative evidences to state that if we retain the capital punishment, there is a decrease in the crime. Okay. So that itself is not a very strong. Okay. We will see that what are the active points also, but I am just talking this way. Second is about the retributive aspect. You are saying that as a date, but and calling it justice. Justice also involved not just the retributive part, but reformative aspect of justice. Reformative. Anybody who has attended my ethics classes should remember this. We have focused a lot on the reformative aspect. The full justice is not about punishing someone, but it is about reforming and bringing back into the society as a normal person. Okay, not eliminating him completely, but reforming him. Eye for an eye will make the whole world blind. Okay, or that is hate the crime, not the criminal. That you have an always chance to reform the person. So the full theory of a justice is not just about retribution, it is also about the reformation. Third is, if you see the globally, that is what is called as the barbaric punishment versus the civilized form of punishment. That we are saying about the retribution, yes, it does not mean, see the only reformative, we are also not calling there should be only reformation. Only reformation will incentivize the crime. Okay, people will say that what is a great deal? We will go and murder and then we will get the ethics lecture and education and reformation and so on and so forth. But there has to be a reformation plus retribution. So here the retribution aspect will be life imprisonment. In fact, they say that life imprisonment kill a person every single day. And in one go you are killing him. That's not even a punishment. The physical death will not cause a sort of an remorse in him. Okay. So retribution, life plus reformative justice. Apart from that, yes, what are the things? Basically, it is a reformative part which we have to see. Second is it is a barbaric act, and if you see the trend across the world, they call barbarism to civilized society. Okay, this shift requires that you have to convert the capital punishment into life imprisonment, plus complemented by the reformative theory of justice. Second is the theory of deterrence. This point has not been well collaborated by the facts and the evidences. Understood? And the most important part, the last. Supreme Court in 2009 in Santosh Kumar versus State of Maharashtra case stated, yes, what it has stated, that 13 times it has happened, there is an error of judgment. Okay, 13 times there was an error of judgment. This is the Supreme Court itself has said that we have given the life imprisonment, capital punishment where it should not have been given otherwise. Okay, or there the rare of rarest jo criteria tha, Bachchan Singh ka, that was not applied, and do ko already execution de diya gaya tha. So there is no chance that you have already, yes, the life has been ended. Even if you have accepted that there is error of judgment, you have no chance to getting it back. Are you understanding? So they say that retribution of the life imprisonment is still a good deterrence. Why? Because if a person is living and the whole life he is away from his near and dear ones, put into the custody, and then there is a rigorous imprisonment for him, that is a good enough deterrence. If the person is dying, in fact, those people, the suicide bombers, they are ready to get killed on the day one only. Okay, it's the due process of law which is extending their life. Otherwise, yes, the one who is indoctrinated. Okay, so these are the debates. Obviously, the answer is cannot be fit into it, but yes, you should just have the points regarding it, but absolutely not. They will not going to ask in case of prelims. Yes, this is about the all the issues regarding Article 21. Yes, now Article 21A. What is Article 21A? What is Article 21A? Right to education. Please have some progressive thinking for the mains answers. LGBT कौन support करता है? Please raise the hands. Who all supports the LGBT rights? अच्छा, good number of people don't support the LGBT. Okay, ठीक है. जाने दो, अब ज़्यादा नहीं क्वेश्चन पूछूंगा आपको मेंस. ठीक है. Right to education. Yes, now this we have to see, first of all we will see what is the text. What is the text? Yes, state will provide, yes, state will provide free and compulsory education. Free and compulsory education to whom? To the children belong to 6 to 14 age group. Again, what is there anything more? As, yes, as state may provide by law. As state provide by law. It means that as per the conditions, situation, resources, etc., they will put the different parameters, okay, in order to enforce this. Although it is, yes, it is a fundamental right, there is no doubt about it, but it will be regulated as per the law. Okay, so the law as per the availability of the resources will ensure the enforcement of 21A. Understood this part? Now, what has to be discussed in this is a little bit of evolution, how it has evolved over a period of time, and this has been added by, yes, 86th Constitutional Amendment Act. This article has been added by 86th Constitutional Amendment Act separately, that therefore that is a 21A. But 86th Constitutional Amendment Act is not just about 21A. There are 3-4 different things have been added. That is about one fundamental right has been added, one directive principle in state policy, and one fundamental duty. In fact, directive principle was not added, it got modified. That is Article 45 here. Here fundamental right newly added, that is 21A, and fundamental duty Article 51A clause K. Okay, so we will discuss that what has happened in 80 this basically. You can remember this way, otherwise. Okay, fundamental right, directive principle of state policy, and fundamental duty. Okay, three things have changed through the 86th Constitutional Amendment Act. Okay, so something which was added, that is 21A, that is a free and compulsory education. Free and compulsory education to the children belonging to 6 to 14. So this is a fundamental right for the children belonging to 16 and 14 age group. In fact, this was the directive principle earlier. Okay, free and compulsory education to the children belonging to 16 and 14. This was Article 45. But since the directive principle of state policies are not enforceable, not justiciable, in fact, the nature of directive principle, even if not justiciable, there is an obligation on the state that in future, whenever you get the resources, you should make it a right. Okay, you should make it a right. So that is what we have seen, that over a period of time, what was written in the directive principle, okay, got shifted into the this. So यहाँ पे कुछ modification हुआ. What is the modification? Yes, how it reads now? Yes, 0 to 6. What is 0 to 6? Education नहीं रहेगा. Primary education 0 to 6 कहाँ पे आएगा? Yes, early childhood care and education लिखा हुआ है लेकिन. Yes, non-formal education. Early, not primary. Early childhood care and education. Non-formal education कौन से स्कीम में दिया जाता है? Yes, आंगनवाड़ी. What is the scheme? ICDS. Basically, there are 6 components within it. Okay, that is about the pregnant lady and the children belonging to 0 to 6. So, non-formal education. Anyways, so early childhood care and education. That is Article 45. So, early childhood कौन सा रहेगा? 0 to 6. So remember that directive principle is related with the 0 to 6, whereas the fundamental right is related with the 6 to 14. 6 to 14 के लिए free and compulsory education, that is a primary education. 0 to 6 है, obviously छोटे हैं तो उनको childhood care and the education. So this will be the responsibility on the state, because directive principle are, yes, state responsibility. Now fundamental duty. Which fundamental duty has been added? That is Article 51A. These are already fundamental duties. There are already, how many duties were there originally? 10. So 10 plus 1 हो गया. That is, now there are 11 duties. So 11th duty was added through the 86th Constitutional Amendment Act. So that is Article 51A K. Okay, Article 51A K. K has been added. So this is a duty. Now since it is a duty, duty is not on state. Duty is on parents or the citizen. So obviously in this case it is on the, specifically on the parents or guardians. Now ये कौन से 0 to 6 के लिए है या किसके लिए? 6 to 14 के लिए. In fact this is nothing but the corresponding to this. अगर state ने school खोले हैं तो it is a parent's responsibility to send the 16 to 14, provide the opportunity to 16 to 14 for the education. So this is in complementary to this. In fact, everything is complementary because we wanted to create 6 to 14 के लिए fundamental right. So it's a natural, you cannot keep directive principle. So it required to be changed. So it has changed for the 0 to 6. मतलब एक और ambitious target आगे के लिए चले गई है, 0 to 6 also preliminary, and then there is a corresponding duty that the 16 to 14 parent should end. So this is about, ये कई बार question पूछा जाता है, 86 constitutional amendment has changed. So they have added, this is an addition completely, this is modification, okay, that is 45 तो already था, and this is again addition. This is addition, this is modification, because number has not been changed, the text of the article has been changed. Understood this? Now let us see one more thing. Earlier, see, the thing is that यहाँ पे जो लिखा हुआ था, एक तो डायरेक्टिव प्रिंसिपल था ही था, इसके पहले एक उन्नी कृष्णन केस था और मोहिनी जैन केस था. ओके, नॉट हैव टू रिमेंबर, जस्ट आई एम टेलिंग. जो अभी हमने आर्टिकल 21 देखा था, राइट टू लाइफ एंड लिबर्टी, तो राइट टू लाइफ के ऊपर उन्होंने एक्सपांड करके वहां पे लिखा हुआ था, दैट इज अ राइट टू फ्री एंड कंपल्सरी एजुकेशन. Earlier, one of the expansion of ambit of Article 21 earlier was to expand the meaning of right to life. Right to life also include right to free and compulsory education. And then finally it become a proper 21A. Are you understanding what is the evolution? So first there was the two cases by the Supreme Court in order to include it as a right to life under the Article 21, right to life and liberty, and then it becomes a fundamental right. Okay. Yeah, it said about higher education in 1992, but 1993 they have scrapped it. Okay, so for all practical purpose, there is no fundamental right. Yes, in 1992 they said, but in 1993 there was a one case where they have cancelled it out. Understood this part? Okay, so the free and compulsory education. Now, naturally, since the word was here, free and compulsory education, as state may provide by law, so there was a law. Okay, what was the law? That is a free and compulsory education. When it came into force? 2009. Okay, 2009, that is integral part of the Sarva Shiksha Abhiyan and those correspondent, and there are so many parameters are given, how many teacher pupil student ratio, okay, etc., those points. Now this is about the this education and this aspect, that is about the Article 21. Now let's come to 22. Article 22. Yes. Right against or right with respect to likho, arrest and detention. How this is different from conviction of offense? There is always a confusion कि इसमें और इसमें क्या relationship है and why it is different, what is in that and what is in this? हाँ. Yes, it is only for the arrest purpose. That is rights, but just about conviction, it means that yes, that is about the punishment, related with the punishment. This is about arrest. Is there any difference between arrest and detention? Only detention word will tell you that it will be, unless stated otherwise, you cannot take detention as only preventive detention. Detention is like putting under detention. It can be both curative detention as well as the preventive detention. Detention is simply arrest. Do not relate detention only with the preventive detention. Okay, generally what happens, arrest we feel that it is ordinary law, and detention we feel it is a preventive detention. Arrest and detention, when at the same, there is nothing. Within that, there are obviously the two categories of detention. That is a curative detention and preventive detention. Detention should put and stop someone. Okay, so that can be done in two ways also. Okay, so let's see now curative. Obviously, it in order to correct after the trial and conviction. Yes, after the offense है, वो बाद में आएंगे उसके ऊपर, जो constitutional provision है. Trial and conviction. Trial and conviction. And preventive is, yes, in order to prevent the crime from happening. In order to prevent the crime from happening. Okay, so the person has not committed the crime, but still, because he is a potential criminal, तो उसको पहले ही yes, he will be put behind the bars for some days. Say for example, गणपति फेस्टिवल है और गणेश विसर्जन है, तो देर आर फ्रीक्वेंट ऑफेंडर्स, उनको पता है कि मतलब कैसे कम्युनल वायलेंस करना है, पत्थर कैसे फेंकने हैं, एक्सेट्रा एक्सेट्रा. सो दे विल क्रिएट अ chaos, okay, taking the opportunity, होली है, ऐसे ऐसी चीज़ें हैं, तो पुलिस के पास लिस्ट रहती है 15 दिन पहले उनको, यस, जेल में होली करो या जेल में गणपति विसर्जन करो, विसर्जन होने के बाद उनको छोड़ दिया जाता है. सो दैट इज अ प्रिवेंटिव. दे हैवंट कमिटेड द क्राइम, but still they are put into the detention in order to prevent the crime. That is the rationale behind it, okay, in the larger interest of the society, because they might create the crime. Now let us see this provisions with respect to the yes, arrest and detention. So there are two different again यहाँ पे. So first part of the article 22 is related with the ordinary laws. लॉ में ही लिखा रहता है वो. देर आर सर्टन लॉज विच वेर इन देर इज एप्लीकेशन ऑफ प्रिवेंटिव डिटेंशन एंड लॉज रिलेटेड टू प्रिवेंटिव डिटेंशन. So you will be arrested. So let us go to this aspect later on. Now come to the normal. Normal when the person is arrested. Okay, not a preventive detention. It means that there are certain prima facie, okay, or some guilty is there and you are still in the allegation. You will be taken to the custody. Now this is called as the ordinary. So your detention is not for preventing. It is for the prima facie fact that you have guilty of some crime. Since you are guilty of some crime, people have arrested you. Not it is that you are going to commit the future and therefore we are preventing. So some sort of crime has been committed. Okay, obviously these are the allegations only. Okay, you are guilty of crime and these are just an allegations. So on the basis of this allegation, if they put behind the prison, okay, inside the prison, in this case what are the rights available to the detainee? Okay, जो भी detainee है उसके rights क्या क्या है? So उसका first right है, that is a grounds for detention. He must know the basis or the ground किस लिए arrest किया गया है. Basis for detention or arrest. Grounds or basis for arrest. So the authority required to communicate to him the grounds for arrest. Second is he will be given a chance to represent his case by the legal or the competent authority. So representation of case by legal or the competent. So he will be given his chance also to say what he has to say. That is generally we call due process. Okay, जैसे कसाब भी रहेगा, उसको arrest किया है, so he will be also be given a chance to say what he has to say, to put forward his case. So first, the basis of arrest will be told to him, and second is he will be given a chance to represent his case by the legal authority. Third is arrest हुआ है, he will be produced before the magistrate within the 24 hours. So within the 24 hour he should be produced before the magistrate. Okay, now उसमें obviously traveling time and etc has been excluded. 24 functioning official hours जो भी रहेंगे तो वो हैं, excluding the time. मतलब फिर वो आ जाता है कि बहुत दूर है, नदी है, okay, facilities नहीं हैं तो क्या हो जाएगा. So all these excluding 24 functioning hours, he should be produced before the magistrate. And fourth is he should be released within the 24 hours if not magistrate के सामने उसको produce करने के बाद magistrate ने बोला है you can continue his detention for a long time. If the magistrate has not said it, then you have to release him also. So these are the rights available to the person who will be arrested. So you have arrested, logically सोचो आप कि आप arrest हो गए तो you can ask for the ground why you have arrested. You will also given a chance to present your case through the legal lawyer. You will be produced in front of the courts within 24 hours. If the court do not find the merit in continuation of detention beyond 24 hours, you will be released within the 24 hours. Okay, so this is if you are charged under the ordinary law. Okay, ordinary law के लिए अगर आपको charge किया गया है. I hope the points are clear. Nothing much to explain here. Okay, now here again there are rights available. Now these are the special cases where there are certain laws. उस law में लिखा हुआ है कि you can also be okay detained under the preventive detention. So here you have not committed the crime. It's only for the prevention of crime. What are the rights available? Let us do this way only so that it will be easy to remember. Grounds of basis of arrest, yes, यहाँ पे भी basis of arrest आपको, it is your right to ask for the basis of rights, and they have to provide the basis of your arrest, even if it is a preventive detention, except for the fact that if there is certain national interest which is going to be served by divulging the facts to you, okay, it is getting threatened, then in certain circumstances they may not tell you. Okay, say for example, आपको अरेस्ट किया गया है कि टेररिस्ट एक्ट के लिए, okay, they are suspecting that you are going to explode the bomb somewhere. Now they have arrested. Now you are asking क्यों, कहाँ पे बॉम्ब रखा था? तो if they will tell you यहाँ पे आपने अपने बॉम्ब रखा था, तो obviously it might threaten the interest. Are you understanding? Otherwise you require to give only in safe special circumstances. You cannot tell. Second is representation. Yes, he also be given a chance of representation of his case, because obviously preventive detention, in fact, which one is more violation of rights? Preventive, because you are an innocent, you are still not committed the crime. So basis of detention should be told to you, presentation of the case. And third is important, which is different from this. Here you will be released in 24 hours if the magistrate will not ask to continue. But here without anything you may be continued for 3 months, not 6 months, 3 months. So the maximum period, उसमें और भी है, पहले बता देता हूँ. So first 3 months आपको वो किया जाएगा. After 3 months, if there is an advisory board, consists of the High Court judges. If this advisory court will tell you that yes, beyond 3 months also it can be continued, so it can last beyond the 3 months also. So जैसे यहाँ पे लिखा है कि 24 hour ही आपको without magisterial power, maximum 24 hours you can be kept without magistrate permission. Here it is 3 months before advisory board, okay, take the permissions to extend it. Now again there is a one more point, I'll mention that point, okay, but at this point of time these are the 3 rights. One more point ये है कि Parliament has an authority to make, say for example, X law, and write within that law that in this particular law, if the preventive detention happens, even beyond the 3 months, such detention can be continued without advisory board. Are you understanding? 3 months, generally ये process follow होती है, that is a 3-month detention, and beyond 3 months you required advisory board. But yes, in very, very special circumstances, Parliament can make such laws and write within that in which class of cases or circumstances, even beyond 3 months it can be continued without even the permission of advisory board. It has been found that most of the time preventive detention law has been misused to settle the scores or to target the communities. First is to target the community, and second is to settle the political scores or political vendetta. So it has been misused by and large. We will see that later, but I hope the point is clear. What are the 2 types? One is protection given under the ordinary law, and one is given protection under the preventive detention law. Do not call curative detention. These are the types, but technically speaking, this part is related with the, if you are detained under ordinary law, do not call curative detention and preventive detention. If you are arrested under the law, which is ordinary law, if you are arrested under the law for the preventive detention, then that is the protection. Okay. Now let us see what is the power of a state and the yes, in order to making the preventive detention law. ये तो law बाकी तो कोई बना रहा है, that is our article 246 or 7 schedule, that is a concurrent list, state list and this thing. Preventive detention के ऊपर जो law बनाने हैं उसके ऊपर what is the division of the power between the center and the state, that we will see. That is the second point within this. Yes, how the power is divided? On the preventive detention law. Which law? Preventive detention law. Okay, कौन कौन क्या क्या बना सकता है? Center या Parliament क्या क्या बना सकते हैं? Parliament can make the preventive detention law with respect to, yes, security of country, then foreign relation and defense. And state can, yes, they can also, obviously concurrent list bhi hai unki, and they can also make the laws on state also. And state can make the law on security of state. Second, law and order. What is the third? Essential services maintenance. Essential services maintenance. जो इसमें कहा जाता है. Okay, so parliament has this. State की ये power है 3, but parliament can also make the law on this subject as well. Okay, on this there is a concurrent power, on this there is a exclusive power. ठीक है? State can make the laws only on the 3 subject, whereas parliament can exclusively make the law on 3 subject, but it can make the law on the 6 subjects. Understood this point? Okay. Do not see this is a division. यहाँ पे लिखते समय ऐसे लिखा है. This is a exclusive division लिखा है. But parliament also has a law to make on rest of the subject as well. Again, see, apart from that, there are 3-4 points you should remember here with regard to that preventive detention. अभी जो मैंने mention किया था. It is the only power of parliament. It is the only power of parliament to maintain some of the things that beyond the 3 months, which are the cases in which even the advisory board permission is not required, that you can continue such detention beyond 3 months without the permission of advisory board. Only and only parliament can make such provisions. Second is beyond 3 months of kitne der tak, that is what is the maximum time. What is the maximum time beyond 3 months under a particular law? That also is a power of parliament only. Okay. And third is what is the procedure that is to be followed by advisory board. जो advisory board अभी देखा था. Advisory board कब आता है? In normal circumstances में. That is beyond 3 months if you have to continue. So parliament has a power to make a law in which they will write that in such cases advisory board permission is not required. Second, they will write the maximum time, and third, they will also write the procedure, okay, to be done by the advisory board. Understood? These are the 3 exclusive powers of parliament. Here the state is not having any power. These are the exclusive powers. Understood? The last point is ये जो 3 months है, 44th Constitutional Amendment Act. 44th Constitutional Amendment Act has reduced this 3 months into 2 months. हाँ बता रहा हूँ. Okay. 44th Constitutional Amendment Act has reduced 3 months into 2 months. But this has not been enforced. Okay, the provision has not yet been enforced. So still the position is 3 months only. But yes, the statute, that is 44th Constitutional Amendment Statute, says the power is, the detention should be only 2 months, and after 2 months immediately you require advisory board to be there. Understood? Again, for the mains there is a debate here. Should the preventive detention be a part of democratic government's fundamental provision of the constitution or not? Because India is the only democratic country which has such provision. Okay, so you have to write both points for and against as per your wish. Okay, so this is about the preventive detention. Yes, any question regarding this preventive detention and whole article 22? Yes, you want to say something?
Detention during emergency is also a part of this law.
During emergency? Yes.
Detention during emergency is 75.
Yes.
It is a part of this law.
Yes. In fact, after emergency only 44th came into existence. Yes, preventive detention, yes, it was there. So many, in fact, जो 42nd Constitutional Amendment Act है उसमें बहुत सारे fundamental rights के suggestions किए गए थे, fundamental duties के भी. एक duty है देखो, that is to make yourself available for the defense of the country when you are called for. Okay, so that is one of the duty which has been, yes, added. In fact, the whole inspiration of fundamental duties was what has happened from 75 to 77. Okay, so there was a lot of people which were acting against so-called state and so-called people as per the view of, yes, government, obviously Mrs. Indira Gandhi. Okay, so in that regard, उनको ये लगा कि can we come up with the provision in order to create a regimented society, और उसको नाम दिया गया fundamental duties. Swaran Singh committee has suggested you can backed by the punishment also, although today that recommendation has not accepted, but yes, there have been cases where the JP, as they were targeting, okay, so they have simply targeted him and rest of the people who were involved in it. In fact, the whole emergency was applied without taking his name, but something what he has said on the evening before, that she has said that हम में से कुछ लोग हैं जो गवर्नमेंट के मिलिट्री और पुलिस को बोल रहे हैं कि do not follow the orders and trying to create a military coup like situation. Okay, तो ये सब उसकी हिस्ट्री है. मैक्सिमम टाइम हर एक्ट में अलग अलग होगा. देर इज नो मैक्सिमम टाइम जनरल. सी दर डू नॉट सी दिस एज अ पार्लियामेंट इज कम विद द मैक्सिमम टाइम 5 years. ऐसे नहीं होगा. उस एक्ट में होगा इफ यू आर कैप्चर्ड अंडर दिस पर्टिकुलर एक्ट. से फॉर एग्जाम्पल पोटा है, टाडा है, अभी बोथ हैव बीन एबॉलिश्ड, यूएपीए है. सो जो भी प्रिवेंटिव एक्ट रहेगा, एनएसए है, उस एक्ट में लिखा रहेगा. तो जितने भी अलग अलग एक्ट है उसके अंडर लिखा रहेगा व्हाट इज द मैक्सिमम टाइम. इट विल नॉट बी अ जेनेरिक, बट 3 months विल बी अ जेनेरिक. 3 months दैट नो मैटर विच एवर इज द एक्ट, आफ्टर 3 months यू हैव टू कम टू द एडवाइजरी बोर्ड. ठीक है, एंड वो मैक्सिमम टाइम केवल पार्लियामेंट डिसाइड करेगा हर एक्ट के अंदर वाला. क्लियर? यस. अभी मको का है, गको का है, बहुत सारे, सभी में एक ही है वो, आर्बिट्री मिसयूज एंड एक्सेट्रा. ओके, लॉट ऑफ पावर इज गिवन, एंड इन फैक्ट दिस पावर इज नथिंग बट द एग्जीक्यूटिव पावर, नॉट इवन द लॉ, बिकॉज पुलिस इज अंडर अगेन द executive authority. So many a times political vendetta and targeting the communities, this has been misused. I hope the discussion is fine with regard to 22, and now let us move to the 23. Yes, what is 23 and 24? In fact, this is now the new category of rights, that is a third category of rights. What is the title? Freedom against exploitation. So there are certain fundamental rights which in fact ask us to end exploitation. Okay, end exploitation. So there are 2 articles here, Article 23 and Article 24. What is Article 23? Freedom against, or you can say that there should not be trafficking and beggar and other form of bonded or forced labor, other form of forced labor. Broadly it read as a end of trafficking and forced labor. Okay, end of trafficking and forced labor. 24 I will write later on. Okay, so end of trafficking and forced labor. So these 3 words are there. Okay, trafficking, beggar, and what are the other forms of forced labor. So yes, what is the trafficking? Yes, human trafficking. Yes, that is buying and selling. Okay, buying and selling of the human beings, that is about the trafficking. What is a beggar? Bonded labor. How? Yes. Without pay there is a work, because say for example your forefather has taken some money फ्रॉम द जमींदार, 444 फादर वगैरह, ठीक है, वो पैसे नहीं चुका पाया वगैरह वगैरह, आपके पास तक आ गया. नाउ यू डोंट हैव मनी टू रीपे बैक, so how the zamindar will say that okay, if you can't pay back, be with me and lifetime you do the work for me. So that's a sort of a begar is a work without any kind of a remuneration, and this is particularly to as a part of a repayment of the debt. Understood this part? That is about begar. So begar is there is no remuneration and the work is being done. So obviously that is a form of exploitation. Any other form of forced labor and exploitation? Manual scavenging also. There are various ways. Devidasi system is one. Okay. So we have discussed. We have already abolished the Devidasi system. Devidasi system. I hope everybody is familiar with it. Okay. Devidasi system.
It's about these girls who are kind of left in the temples and the name of the text of marrying God, but they're actually exploited.
Yes. Okay. That is for the common purpose. Okay. If you have seen Mangal Pandey देखा है क्या, रानी मुखर्जी का role, if you have seen. Okay, so this is sort of a temples, and then the women were put, okay, and obviously for the purpose of public. Okay, so it's a sort of an exploitation. There is no free will. There is a absolute where say that the misjudgment with respect to individual conscience. Okay, there is no individual conscience for them. There is no free will for them. Obviously, it is in the form of the exploitation. So any kind of a Devidasi system, bonded labor, begar, trafficking, everything should be abolished. Okay. In fact, the constitution says that there is a end to all these things. Okay. There is end to all these things. And second is, if at all somebody is doing it, then it will be considered as offense punishable under law. Punishable under law. Something like what we have discussed yesterday in case of abolition of untouchability. Okay, same thing was written, that is there is a abolition of untouchability. मतलब untouchability formally abolish हो चुकी है, but any practicing other forms of untouchability is forbidden, and if it is untouchability is there, then it will be considered as offense. So here also they are declaring the same things. We have abolished everything: trafficking, beggar, Devidasi system, etc. And if at all in some form it is continued, it will be considered as offense, which is punishable by act. So yesterday we have seen the two acts. What were the name of two acts under the untouchability? Yes, Protection of Civil Service, Protection of Civil Rights Act. Okay, Protection of Civil Rights Act, which was named as, earlier it was a Untouchability Protection Act, and Atrocities Prevention Act. Okay, that is SCs and STs atrocities. Here, what are the acts? Can anybody tell me one or two acts? Yes, Prevention of Immoral Trafficking Act. Okay, Immoral Trafficking Act. Yes. Bonded Labor Abolition Act. That's the second. Any other? Juvenile Justice Act. Juvenile justice, because bonded labor many times women and children are there in case of a bonded labor. So Juvenile Justice Act. Okay, Bonded Labor Act. Immoral Trafficking Act. So these are the acts which help in curbing the any kind of a forced labor that is existing. Understood? Is the prostitution legalized in India or it is not? Is the prostitution punished? It is legal? Somebody is saying it is legal? बताओ मुझे कोई specific. Acha, you mean to say that it is not being called sacred act? So, for money you cannot, otherwise you can. Which law you are reading? From Pakistan law or what? Yes, what is the position of prostitution in India?
It is allowed in a private house also,
Yes.
but not in public place or 100 meters.
Okay, yes, you are very close now.
So it's allowed. Now the pimping is not allowed.
Yes, what is not allowed is a pimping. I hope everybody understand pimping, crawling, pimping, brothels. Okay, so the individual, the woman who is involved in the act of the sex, she will not be punished in any case, whether it is 100-meter or anything of that sort. But whatever the surrounding things are there, okay, the client, the brothels, the pimps, the middleman, so everything will be punished. Immoral trafficker, the one who is picking up jo brothel mein usko leke aa raha hai. So this has been kept because she is a vulnerable, too vulnerable. So she will not be punished, but yes, rest of the things are punished. In a way, what is it creating? It is creating a situation because she is not punished. Maybe if you are doing it privately, obviously, as you are saying, so obviously the court, the law cannot go and capture it. As long as you cannot capture the brothels members, you cannot capture the pimps, the act is fine. It means that if you are if at individual level, if the women is selling her body and these things, there is no act as such because there is no pimps and this thing. So there is a lot of complexity in the act with respect to this. They also say that if the state has a will to stop the prostitution from happening, these are the various laws. मतलब इन्होंने जो बोला कि 100 मीटर, the women cannot, मतलब जो वो करना समझ रहे होता है, मतलब there is a process called as crabbing मतलब जो हाँ बाइक हाँ धीरे धीरे चलना, तो 100 मीटर में अगर आप पकड़े गए तो you will be punished. Okay, so that is there are legal complexities. तो उसमें काफ़ी सारा gray areas है. Because of those gray areas, the things are still continued. Now they are seeing that since things are continued, why not to legalize it completely? Because there are certain other positive aspect of it. Positive aspect क्या है? Legalization of prostitution. They will come under the labor law, so they can have the trade union, they can ask for their rights. There is no exploitation by the client, exploitation by the brothels, exploitation by the police. Okay, so there are different stakeholders. The one who is coming, client is coming, and then he is not paying the cost that he has promised before the act. Second, the brothel person is not paying the full amount. Third, police is trying to blackmail that I'll put you into the jail, etc. So again, that thing is happening. So it is unregulated, and therefore there is an exploitation. Yes, that's a one advantage. Any other advantage? Any other advantage? What are the points for the legalization of prostitution? Health aspect. What is health aspect? Yes. Yes, AIDS and HIV. Most of the times, these are the sources of sexually transmitted diseases, STDs. So, in case of a NACO or National AIDS Control Program, they are not able to trace the source. So, if it is legalized, they can easily able to go to the source, and they can have the better intervention for the AIDS control policy. Yes, any other? It will increase the revenue of the state also, because employment, if it is becoming illegal, so obviously taxation and other things will come, but that's a very peripheral point. Yes? Stop? Trafficking. Yes, there are good number of points to say that it can stop trafficking also, but there are other points which they say that it might increase the trafficking also, because those who are hiding and carrying out, they will come openly and they will bring in and go for it. Those who are supporting trafficking might reduce. They are saying that since the law will be there, so the police can handle only the genuine cases, those who really want to go for it, and not those who are being forced. So at least the police can intervene into the matter. So these are the points of whether to legalize. Anyways, so that's about it. Okay, this is about act. That is act mein this has to be abolished, and there are certain acts which makes this as an offense, and they are punishable under it. Okay, next move to the Article 24. What is Article 24? Yes, the Constitution reads it as there is a prevention of, or you can say that preventing the children below the age of 14. Children below the age of 14 working in a factory, mines, or hazardous condition. Basically, it is hazardous. Factory, mines, less than 14. This is what is the Constitution Article number 24 reads. Less than 14 years, okay, the children should not be employed in hazardous condition. But now there has been a lot of, again, progress has happened. Okay, so the progress was, yes, earlier what was the situation, and very recently there has been sudden change.
Like now they're allowed to work in the farmlands.
Yes, before that what was the change? Before that, Yes, less than 14. अभी जो हुआ है वो तो देखेंगे हम. What was the existing situation? Less than 14 years, it was banned. Yes. Yes, it was banned only for specific 18 categories. Specific 18 categories. They have banned specific 18 categories. Less than 14, you cannot employ the children in specific 18 categories. And more than 14, obviously, there was nothing. Okay, because as per this, less than 14, you just avoid the hazardous. Okay, implicitly it means that more than 14, you can go for hazardous also. It also implicitly means that less than 14, you cannot go for the hazardous, but you can go for the rest of the things. So rest of the 18 things were there. Now what has changed is, and there was a crime, crime के लिए जो punishment थी वो भी लिख देता हूँ, मतलब बाद में discuss करूँगा मैं. There was a punishment. Now, yes, this might be the question can be asked this year because there has been a change. Yes, you can expect this question on very recent amendment has happened. It has been passed or it has just a bill or suggestion. Has it been passed? I think it is passed. Yes. Yes, what has changed now? They are saying that less than 14, it is banned, except, but in fact it is a very dangerous except, because it is like they are saying that cowardly, okay, all the things are getting started. Banned except in family enterprises, then sports activities and entertainment, ऑडियो विजुअल एज दे से. ओके, ये तीन छोड़ के, बट ये तीन काफ़ी बड़े हो जाएंगे बिकॉज, एंड यस, वन मोर पॉइंट दे हैव एडेड इन दीज थ्री केसेस व्हेन देयर इज अ यस नॉन स्कूल आवर्स. ये लिखने के लिए का बहुत ज़्यादा लिख देते हैं, ठीक है, बट कुछ होता नहीं है ये. दीज आर ऑल द बैकडोर एंट्रीज. ओके, फैमिली एंटरप्राइजेस मतलब फैमिली में पेरेंट्स को हेल्प करना मतलब ऑब्वियसली दे वही करेंगे वो. ओके, बीडी बनाना है, कारपेट बनाना है, ये सब चीज़ें जो बनानी है तो बनाएंगे. बट लॉ सेज दैट फैमिली एंटरप्राइजेस इन नॉन स्कूल आवर्स, बिकॉज इफ यू आर राइटिंग दिस you are also coming up with the act that free and compulsory education. Now there is a conflict when on one side you are saying that 6 to 14 there is a compulsory education, matlab kid has to be there in the school and then he can also do the this function also. So therefore it is important that is a non school hours. स्कूल छूटने के बाद फिर वो काम करेगा. उसमें वो लिखा हुआ है कि देयर विल नॉट बी एन सबऑर्डिनेट रिलेशनशिप विथ रिस्पेक्ट टू वर्क. मतलब ऐसे नहीं है कि मैनेजर है फिर वो चिल्ड्रन इज अ प्रोलिटरेट, फादर इज अ कैपिटलिस्ट क्लास, ऐसे रिलेशंस नहीं है. मतलब वो इनफॉर्मल मज़े मज़े में काम करना है उनको. दैट्स द लॉ इट रीड्स. सेकेंड इज स्पोर्ट्स एक्टिविटीज एंड एंटरटेनमेंट. व्हाट डज इट मीन्स, विच काइंड ऑफ अ वर्क? स्पोर्ट्स, हाँ, क्या मतलब खेलना इज अ वर्क? हाँ, यस, दैट काइंड ऑफ अ थिंग. या फिर ऐसे बॉल उठाना है, ऐसे मतलब जो सब्सिडी काम लगता है. एंड सेकंड इज अबाउट एंटरटेनमेंट. ओके, सो एंटरटेनमेंट इंडस्ट्री में सो जो भी छोटा मोटा काम है सो दे आर परमिसेबल. बट यस, इंडियन नोबेल लॉरेट वाज अमर्त्य सेन. नहीं, यहाँ पे अमर्त्य सेन क्यों बोलूँगा? हाँ, कैलाश सत्यार्थी. ओके, yes, your answer was right to that extent. Nobel laureate was Kailash Satyarthi was not very happy because he was saying that it's a sort of a backdoor entry, but government has gone ahead with it. That is the first point. Okay, remember what has been changed may be asked. This is the first point. Second, what about children between more than 14? So they have come up with the new category 14 to 18. The law comes up with the new category. What they are calling them? Adolescent. Okay, adolescent. Adolescent में all होगा but hazardous नहीं होगा. Okay, no hazardous, otherwise everything will be there. Except hazardous, everything will be there. And third change that they have made, third change that, ये समझ में आ रहा है ना? All are banned except three. Except three मतलब three मत पकड़ो, उसमें बहुत सारी एक्टिविटीज आ जाएगी. 3 areas, फैमिली एंटरप्राइज बोल रहे तो वो एक नहीं होगा, उसमें सभी इंडस्ट्री आ गई वैसे बोला जाए तो. Are you understanding? So it's a very broad category, but as law reads it, ban except three. Then except three भी नहीं बोलता है, ये हम काउंट कर रहे हैं ऐसे, फैमिली, स्पोर्ट्स एंड दिस थिंग. Here it is adolescent, everything except hazardous. Third is increasing the, it is making the law stringent. मतलब जिन्होंने इसको violate किया, जिन्होंने इसको violate किया, the one who will be violating this law, yes, punishment has been increased. How much? Yes, anybody know? Yes, from 6 months to 3 years. Earlier it was 3 months to, ये जरूरी नहीं है earlier क्या था, but just याद रखने के लिए 6 months to 3 years, 3 year या 2 year, sorry. This is first, and second is from 20,000 to 50,000. Again इसमें वो रहेगा कि first time offender, second time offender को ज़्यादा punishment होगी. First time offender को 20,000, second time offender को 50,000. Earlier it was 10,000, 10,000 to 20,000. So वो cost बढ़ा दी गई है अभी 10 to 20 की जगह 20 to 50. And the minimum punishment was 3 to 1 year, which has been increased from 3 मतलब 3 months, 3 months to 1 year, which has been increased to 6 months to 2 year. And again repeated offenses के लिए increase हो जाएगी. Are you understanding? So this is the 3 changes that they have brought in. First, less than 14 ban except 3. This is the new category altogether. Okay, adolescent, this term was not there in the earlier act. जो भी amendment आएगा, 14 and 18, they are calling it adolescent as a new category, and the punishment has been more stringent. Yes. पर किड को नहीं रहेगा वो, हाँ मतलब जो ऑफेंडर रहेगा, पर किड कैसे रहेगा? नहीं नहीं नहीं, ऐसे क्या मतलब, ऐसे पनिशमेंट कहीं काउंट होती है क्या? मतलब 4 बैंक में रॉबरी कर दी तो टोटल किया जाता है? हाँ, 50 साल की पनिशमेंट. उनको फाइन है? नहीं नहीं, ठीक है, इनको फाइन है. अब वो पैसा जो होगा, क्या नाम है, पीसीआर, जो National Commission for Protection of Child, okay, there will be in provisions, but not directly will go to that. Okay, the victim, because victim here is a children, so he will be rehabilitated. Okay, what we will do by giving the monetary sum? Okay, it's a larger part of the government that इनका rehabilitation करना पड़ेगा, etc. Okay, so these are the yes, punishment, that is a prison as well as the monetary punishment. But again, you see that that punishment is not very. Yes, 50,000 is what? Okay, 20,000 and 50,000 is a punishment. Okay, the one who is employing in an, obviously it will be an hotel. Okay, if he's hazardous industry में तो इतना मतलब बड़ा वो venture है, so it's nothing. Okay. Anyways, and 6 months, छोड़ दो, चलो, we will not comment on it. Okay, so this is the whole issue about the. Yes, freedom. Please remember this recent modification, what it was earlier and what has been now. Okay. Now let's move to the next. Yes, what is the next act? 25. Now थोड़ा सा जल्दी करते हैं. Okay, we have to finish a lot. Yes, Article 25. Now this is freedom of religion from Article 25 to, yes, 25, 26, 27 and 28. This is the fourth category of rights. So we will discuss Article 25. Article 25. Article 25 gives a freedom to individual. Freedom of religion to individual. Now it includes 5 different terms within that. What is the freedom? Freedom of conscience, freedom to profess, then freedom to practice, and then freedom to propagate. In each there is a controversy also, and you should please remember this thing very properly. Time and again these are asked. We are again going to see, this is a freedom that has been granted. Then we will see the exceptions also. That is, what are the limitations. Yes, first let us understand these 4 freedom have been given to an individual. Now freedom to conscience, these 3 are, this is called as inner freedom. This one is inner and this is the outer. I'll explain that what it is inner. Freedom of conscience means what is your conscience, your belief system, your faith, individual faith or belief. Now it is up to you what is your inner association with the God. It is left to you. It is left to a personal individual. That is what is your faith with respect to which God and what God. Here you are not expressing to the people. आपके मन में ही रख रहे हो, आपकी मतलब आत्मा में है, मतलब heart में है. This is what I revere and etc. So that is our conscience. Now the moment profess is you express so that people can see it. Yes, you have this faith. Okay, so profess is about expression of belief or faith. Expression of belief or faith, it means that you can openly declare verbal communication ke through or through the symbolic communication also. Like in case of a Sikh, there is a kripan, okay, use of kripan, 5K hai na? Kripan, Katar, Kach, Kang, okay, and Kada hai shayad, okay. So these are the 5 that one can identify that, yes, he is a Sikh. So that's about the profess, that you are expression हो गया उसका religion का. यहाँ पे केवल within your side था, but यहाँ पे it get expressed. So you have freedom of expression. You have freedom of expression of your religion. Not only symbolic, but it can be verbal. You can declare also that this is my religious take. Third is practice. Now this is different from this. This is only an expression of it. This involves the rituals. This involves the rituals, rites, ceremonies, whatever the rituals which can be practiced by your religion, so you can go for it. Okay, मतलब यज्ञ करना है या फिर जो भी मतलब meaningless rituals also will be a part of it. You have the freedom to do it, whether it is a meaningless or whether it is a meaningful. So rituals, rites and ceremonies has also been granted to as a freedom. And then propagate, this is very important. See, the thing is that I believe in God, I express it to the people, I follow the rituals, okay, जिसको बोलते कि practicing religion बोलते, मतलब आप temple में जा रहे हो, these are the all sort of rituals, and I propagate. What does the propagate involve? Spreading the message, but it is a very benign spreading the message, okay. मतलब आप spread, say for example, I am spreading the message, and if you get inspired, motivated, okay, etc., and you voluntarily feel like to changing your religion and getting with my religion, then it is fine. But propagation does not involve, I will force you to go for a particular religion. Are you understanding? I have this right to propagate from any platform. Okay, I can go through the public platform, I can propagate. And if the person is getting impressed, he has a voluntary every reasons to change and come to my religion. Okay, so propagation also involves voluntary conversion, if at all it is happening, but it has to be a voluntary. Now, what is not permissible if I am forcing someone, that is a forcible conversion. Force may be 2 चीजें आती है. It's not just about the intimidation, it is also about inducement. घर वापसी. Okay, आधार कार्ड मिलेगा, ये मिलेगा, गाजर मिलेगा, लॉलीपॉप मिलेगा, so on and so forth. So it is not intimidation, but it is inducement. You cannot induce also, because it is impinging upon conscience. Because what you are essentially doing, you are not allowing that person to think individually of his own. You are either inducing or you are intimidating. डरा तो रहे हो, नहीं तो उल्लू घुमा रहे हो. In either of the case, you are taking his right of conscience. But Why conversion has to be there? Because if there is a conscience, there can be it is your, at any point of time you can think of any kind of the religion. So if you feel today Hindu, tomorrow Muslim, day after tomorrow something else, you have that reason. So voluntary conversion is fine, but not the forcible. So you should remember, see, you can go for the propagation, but propagation does not involve forcible conversion. But voluntary conversion is fine. Understood these points? Again, let me take this. इसमें confusion क्या सकता है? Kripan क्या है कि something sort of maybe creating threat and insecurity. But Constitution has accepted Kripan is a part of profess. Kripan समझ रहे हो? It might create a problem for the trouble कि somebody is armed. How can somebody, one particular religion can be armed? But Constitution says that because it is a part of profess, not practice, do not come as a practice, it is a part of a profess because it is an expression. Practice के अंदर there are certain debates, that is rituals, जैसे मैंने कहा था कि अभी meaningless rituals and meaningful, there can be some absolutely meaningless rituals to an extent that they are the social evils also. Now such meaningless rituals, the court or the state can decide that whether such ritual should be the part at all or not. Okay, Indian state has an authority, and they have gone for what is known as the essential religious practice doctrine. Essential religious doctrine says that there are certain rituals which are heart and core of the religion. But if there is a social evil, say for example, there was earlier, in case of one religion, they used to take the skulls समझ रहे हो? Okay, dead body के, and they used to dance with it. हाँ, था ऐसे, ठीक है? So that was a ritual for. So court has said that no, such, अगर हमने कल ये बंद कर दिया कि आप स्कल के साथ डांस नहीं करोगे, so आपका religion भ्रष्ट नहीं हो जाएगा. Okay, this is not a essential religious practice. Okay, essential religious practice मतलब we are not entering into your religious practice to an extent that we want to target your religion, but we have also a responsibility to remove the social evils. Are you understanding? So this is related with the practice. So क्या permissible नहीं है पता होना चाहिए यहाँ पे. Okay, something a state can go here also, and propagation they can go here also if it is a forcible conversion. In fact, many of the state have gone for the coming up with the act. Okay, forcible conversion act जो है काफी सारे state में है. In this context, we are seeing the exceptions. So what are the exceptions? There are 4 things here. That is, first is, yes, what are the exceptions? Yes, anybody know? Public order, morality, health है क्या? Other provision of constitution. Other provision of constitution. Now this is very important, other provision of constitution, because if आप ये temple entry and all such things है, so it impinges upon the sex determination. Okay, sex discrimination, sex discrimination है, तो other provision of constitution, so other provision of constitution like there will not be discrimination on the basis of sex. So other provision, so यहाँ पे आप ऐसे कोई freedom नहीं है जिसमें आप फिर से यहाँ पे classify करने लग जाओगे. Understood? Public order, if it is something, a sort of a religion which is creating a disturbance for the public order, morality, health, इसमें ये भी आएगा आप जो संथारा है, whenever the Supreme Court will see, what Supreme Court is going to do, Supreme Court will going to test whether the santhara is a essential religious practice. Okay, so they are going to debate upon it, that whether it is a essential religious practice. It means that if santhara will not be there, जैन खत्म हो जाएगा क्या, ये क्वेश्चन वो देखेंगे. In fact, the High Court of the Rajasthan has already said that we didn't find any evidences, okay, ancient and this textbooks में कहीं हमें ये नहीं पता चला कि संथारा is a essential religious practice. That's why they struck it down. Okay, it is not just about Article 25, it is also about Article 21, freedom of life and liberty. So life and liberty भी है, Article 25 भी है. These are the 4 exceptions: public order, morality, health, and other provision of constitution. Apart from that, ये Article 25 में ही लिखा हुआ है. Apart from that, second, that the Article 25 explicitly mention the state can intervene. The state can intervene into secular aspect of religion. Okay, हाँ, positive मतलब it has nothing to do with the ritualistic aspect. Secular aspect मतलब managing the finances and other regulations, which has nothing to do with the, yes. And second is about the social reforms, social reform or religious reforms, religious reform, religious reforms, or throwing open the Hindu temples, etc., Hindu institutions, opening the Hindu institutions, religious institutions for all category of people. Now, what does it mean? यहाँ पे state का intervention. See, this is where the problems of secularism comes in India. There are certain provisions which gives a chance for the state to intervene. And if the state is intervening, there will be always a hue and cry within the public that state is intervening into one religion as compared to the other religion. So there is always a trouble because the doctrine of complete separation, in the first class I have discussed, that is a secularism is a complete separation, but we don't have complete separation. We have the positive notion that we can have a equal treatment for all religion. The word equal treatment is written, but whenever the state is doing anything, people will say that only one religion is targeted and not targeted. Now here, when the state is entering into secular, there should not be any confusion on the secularism because this is a non-religious activity. There cannot be any confusion on this. State can intervene into the non-religious activity. Here, what does it mean? Throwing open of the temples. मतलब हिंदू रिलीजियस में कई सारी हिस्टोरिक प्रैक्टिसेस है. से फॉर एग्जांपल अनटचेबल्स वेर नॉट अलाउड टू एंटर. सो इन दैट रिगार्ड स्टेट कैन इंटरवीन एंड कैन से दैट this Hindu religious temples can be open to all category of people, okay, all section of people. Or they might say that it is open to both the genders, okay, both the genders, because now as we talk today, there are so many things happening with regard to women discrimination entering Shani Shingnapur hai ya fir Sabrimala temple, etc. Okay. Also, now the most important part, there are two explanations also given in this article that the word Hindu does not mean only Hindu. Okay, the word Hindu means, yes, Jain, Sikhs and Buddhism. Okay, Buddhist. So the word, nahi, Parsi nahi, theek hai. Subramanyam Swami would like to say that even Muslims will be the part of Hindu. Okay. Jews are also. He will say everything. Matlab, he will find out the lineage. He will scientifically prove also some other way. Okay. So the point is, no, the constitution only talks about Sikh. They talk about Buddhist and they talk about Jain. In fact, if you have seen the history, the Buddhism and Jainism are nothing but the rebellion child of Hinduism, and Sikh also has emerged out of the fold of Hinduism. So that is the reason they are the part within the term called as Hindu. That is explanation number one. Explanation number two is Kripan. That is a Kripan, whatever they use, Kripan. Do not like say that how can he be armed and moving with the Kripan. It is a part of profess. Okay, so these are the two explanations which have been provided. कई बार question आता है multiple choice में. Okay, so you should remember three parts I am discussing here. First part is what are the freedom granted. 4 freedom have been granted. Exceptions, exception in 2 ways. These are the 4 specific exception plus second is state intervention. State intervention, secular aspect, and state intervention for the reform. And then third part is 2 explanation. Explanation number 1, the word Hindu involves Sikh, Buddha and Jain. And second explanation, Kripan, is about the part of the profess. So that's about the article 25. Are you following me? Okay, so let's come to the article 26 now. See, there is a difference in between 25 and 26. 25 is individual freedom, whereas the article 26 is a group freedom, collective freedom. Okay, article 26 is a collective freedom. So in case of this, the word is that is a religious denomination. Religious denomination, entire religious denomination, you can say that, or section of religion, or section of religion. Here the word is not individual. Okay, so it means that these are the group or the collective rights. So the right is granted not as an individual, right is granted as for a full religion or some section. This is sect रहता है. Okay, that is Arya Samaj as a sect, Ramakrishna as a sect. So anyways, even if it is a sect, it is a group only. Okay, it is not an individual. So group right क्या क्या है? इसमें 4 rights है. First is, yes, what is the right? They can, yes, establish and maintain the religious institution and trust. Second is they can administer establish and administered. Third is related with the property. They can acquire movable or immovable property. The focus is not on movable and immovable. It is about they can acquire the property. This you should remember because there is an abolition of right to property as a fundamental right for single individual. But for group religion, still you have a fundamental right. Okay? So this can also be, matlab, which one of the following is correct with regard to right to property aa sakta hai? That it has become this, it has become this. Even the religion cannot have the property. No, that's wrong. Okay, it is still a fundamental right that the religion can acquire. Religion in group, again, you as an individual, as a part of religion cannot do it. Okay, so you can acquire the property. And fourth is regulation of property, regulation or administration of property. Regulation and administration of property. Regulation and administration of property as determined by law. So I'll explain this. Nothing much here. The only important aspect you should remember is 25 is for the individual religion, 26 is for the group religion. Group can establish the religious institution and the trust. मतलब बिल्डिंग बना सकते हैं, ट्रस्ट बना सकते हैं, एंड दे कैन एडमिनिस्टर्ड. इसमें तो कोई कंफ्यूजन नहीं है. दैट ग्रुप कैन क्रिएट अ डिनोमिनेशन एंड द ट्रस्ट एंड दे कैन एडमिनिस्टर्ड. They can have the property and they can administer also. But ये administration right absolute नहीं है. This can be regulated by law. That is a state by law. मतलब acquisition of property, yes, you have the right, but administration of property, it will be regulated by the law. Okay, and how it will be, again, regulation does not mean you can take away whole administration. Regulation is only, yes, you can regulate in some other way, you can put certain conditions, but you cannot put a state person to regulate the property of the trust, which has happened in case of one of the temple in case of Tamil Nadu, that is a Nagarjun temple जो है. Nagarjun temple में 2013 में क्या हुआ था? Because there is a lot of mismanagement of the property of the Nagarjun temple, they have appointed the CEO, okay, officer, some state government officer they have appointed. Supreme Court has struck it down. You can regulate, you cannot completely take away the administration of the property. Understood this part? So there are 4 things: establish and administered institution and trust, establish and regulate the property. But property acquisition is absolute, but regulation is not absolute, it is regulated. Again, regulation does not mean complete abolition, it only means a regulation. Is there any confusion? Okay, that is it about 26. Shall we move? Okay, law केवल 4th को control करता है, इतना याद रखो. Law do not enter into this. Law only control the administration of property. Yes. There are exceptions also, something like we have already discussed. वही exceptions है. क्या थे पहले? Public order, morality, health. Okay. Other provisions of constitution नहीं है यहाँ पे. Okay. There are only 3 exceptions. So ये एक exception and law, whatever the law is there for the movable property. Come to now Article 27. What is Article 27 related with? Freedom from payment of taxation, which can be used only for one particular purpose. See, one of the principle of secularism is state will not intervene into the religious aspect. It means that state will not patronize or promote one particular religion. Okay, if state is doing so, then it is not a secular because you are promoting one particular state. So, in fact, Article 27 says that freedom to pay from the taxation and such tax will not be used for promotion of any single religion, any single or any particular religion. Now this is very significant point. जो भी tax collect करता है state, if it is promoting single religion, what will happen? Then obviously it will threaten the secularism. ये implicitly इसका मतलब क्या होगा? That state can go for promotion of all the religion. Okay, without any kind of discrimination, state can go for promotion of all. And this is where again the problem of secularism in India. Okay, it don't say that you cannot promote one, but it means that you can promote all. Okay, so it creates a space for a state to promote or to give a equal treatment to all. That's why I use the word, it is not dharma nirapeksha, it is a sarva dharma samabhav. It is not a religiously neutral, it is a equal treatment to all the religion. Are you understanding? So this Article 27 prohibit an individual to pay the tax which can be used only for the promotion of single religion. Okay, single or a particular religion. That's the important aspect. So यहाँ पे एक religion को आप promote नहीं कर सकते, but it also means that it can promote all religion equally. इसी वजह से ये problem आ जाता है कि हज की subsidy है. Now you are giving the subsidy to the Hajj. Now technically speaking, you can also be right because you can show that we are spending this much on ये जो कश्मीर कौन सा रहता है जम्मू में अमर यात्रा, हाँ अमरनाथ यात्रा के लिए हम ये कर रहे हैं और किसी रिलीजन के लिए कुछ कर रहे हैं और किसी के लिए, तो हज इज ऑल्सो परमिसिबल बिकॉज यू आर ट्राइंग टू डिस्प्ले दैट ऑल द रिलीजन्स आर इक्वी डिस्टेंस फ्रॉम अस. बट अगेन देर इज नो ऑब्जेक्टिव थिंग कि हज को 500 करोड़ है, इसको 500 है, इसको 500 है, इसको 500 है, इसको 500 है. Okay, so there will be always a secularism, pseudo-secularism and toxic secularism, so such kind of things will emerge. इसलिए सुप्रीम कोर्ट ने बोला है 2012 में, yes you spend the money on minority religion and any kind of the religion, but you try to spend the money on the non-religious activities. मतलब आप उतना ही फंड मुस्लिम को ही जाने दो, उतना फंड इसको जाने दो, but promote the educational aspect, social aspect rather than the completely religious aspect. So next 10 years में you try to reduce the subsidy and after 10 years you abolish it for the religious activities. But they are not saying, court is not saying you remove money altogether. Okay, that much of money you can still use for that particular religion only, but for some non-secular activity. Understood this part? So it means that tax cannot be used for one particular religion, but it also means it can be used. Also there is one thing you should remember, tax is not equal to fees. So state can go for collection of fees for particular religion. क्योंकि फीस में और इसमें डिफरेंस है, फीस इज फॉर द नॉन सेकुलर पर्पस. मतलब एक टेम्पल है, टेम्पल की सिक्योरिटी मेंटेन करनी है, आपको वहाँ पे पुलिस रखनी है, पुलिस के लिए जितना खर्च लग रहा है तो लोगों से आपने पैसे रख के वहाँ पे सिक्योरिटी प्रोवाइड किया. आर यू अंडरस्टैंडिंग? सो सच फीस इज परमिसिबल. The fees that will be used for protection of temple, protection of mosque. So it has nothing to do with promotion of particular religious activity. So fees is permissible, that too for the non-secular activity. Tax is not permissible for spending on a particular religion. Understood this? So freedom from payment of the taxes that is used for the promotion of single religion, that has been prohibited. Understood? 25 is for the individual, 26 is for the group, 27 is related with the expenditure of the tax. 28 now. What is Article 28? Freedom to attain the religious instruction in the educational school. Okay, कि educational school में if there are religious instruction, एजुकेशनल इंस्टीट्यूशंस है, एजुकेशनल इंस्टीट्यूशंस, देयर मे बी रिलीजियस इंस्ट्रक्शंस और रिलीजियस प्रोग्राम्स जो भी रहेगा, ठीक है। तो शुड वी अटेंड द वन पर्सन, उसका कुछ राइट है क्या? से फॉर एग्जाम्पल ही बिलोंग्स टू सम अदर रिलीजन और ये कुछ एक स्पेसिफिक रिलीजन है, सो what is your right, that we are discussing. Many a times question is also asked, how many categories of schools have been divided, matlab class of schools under article 28? So answer is 4. Okay, there are 4 types और 4 types में situation क्या है हम देखेंगे. Okay, अलग अलग स्कूल में अलग अलग rights है. First is wholly maintained बाय स्टेट. होली, ये पूरा का पूरा मतलब स्टेट फंडिंग देगा. द वर्ड इज होली मतलब कंप्लीटली. अगर कंप्लीटली अगर स्टेट मेंटेन कर रहा है तो ऑब्वियसली नो रिलीजियस इंस्ट्रक्शन. ओके, सो नो, क्योंकि स्टेट का स्कूल है, वो स्टेट ही पूरा फंड कर रहा है एक्सेट्रा. सेकेंड इज एडमिनिस्टर्ड बाय स्टेट, एडमिनिस्टर्ड बाय स्टेट बट इस्टेब्लिश्ड, इसको बड़ा लिख रहा हूं मैं, इस्टेब्लिश ऐसे वर्ड है, इस्टेब्लिश बाय ट्रस्ट और रिलीजियस डिनोमिनेशन. इन्होंने इस्टेब्लिश किया है, भले ही वो स्टेट एडमिनिस्टर कर रहा होगा, लेकिन द स्कूल इटसेल्फ हैज बीन इस्टेब्लिश बाय द ट्रस्ट और द रिलीजियस इंस्टीट्यूशन. तो इसमें यस, okay, they can give the instruction and here they cannot. Understood? Do not get confused by this. ये आता है word administered by state, आपको मतलब yes confuse करने के लिए. Even if the administered by state word is coming, you have to find this established by this thing. That is about yes. Now third and fourth category. Third is yes, aided by state, and fourth is controlled by state. हाँ, प्राइवेट है, लेकिन से नेचुरली यहाँ पे क्या रहेगा, प्राइवेट विच इज एडेड, प्राइवेट विच इज कंट्रोल्ड. सो एडेड मतलब फंडिंग यहाँ से आ रही है, एंड कंट्रोल्ड, इन दोनों में क्या है, यू कैन डू सो विथ परमिशन, विथ कंसेंट, with consent of those children which are coming into the school, so with their permission. अगर वो बहुत ही lunatic and small है तो उनकी parents की consent रहेगी. So yes, but with consent. Okay, so question if it is asked, I'll explain that again. 4 types of educational institutes. The educational institutes which is completely maintained by state. In such institutes, you cannot provide the religious instruction. It means that the children have all the freedom not to attend the religious instruction. Matlab they cannot, even if they will not go, nothing will happen. So it is this. Second is if it is established by, then the authority has every right. Matlab school में ही करेंगे वो, मतलब obviously they will start the religious instruction because they have established. थर्ड एंड फोर्थ कैटेगरी में पार्शियल है, इस्टेब्लिश तो प्राइवेट ने किया है, लेकिन एडेड इज बाय द स्टेट, एंड प्राइवेट ने इस्टेब्लिश किया है लेकिन इट इज कंट्रोल्ड बाय. सी द थिंग इज दैट एडेड एंड कंट्रोल्ड है, डोंट गेट कंफ्यूज. एडमिनिस्टर्ड, ओके, एडमिनिस्टर्ड में नहीं है. You have to, with the administered, you have to identify the word established. If it has been established by the religious denomination, then yes, yes, with consent. In these two, with the consent, one can give the. Are you following me? What is happening here? See, let us assume this coaching institute, and it is completely wholly maintained by state. So I cannot give you the religious instruction because I am a state, and if a state is giving a particular religious instruction, it will hamper the secular credentials. So if it is completely a state, there is no possibility the religious instruction can be given in educational institute. Now second, let us understand this institution is established by trust. एक trust है, कोई religious trust है, Ramakrishna trust, yes, any kind of a trust they have established. Although the administration is state, but originally it has been established. Since they have established it, obviously they will give it. That is the yes instruction can be given. So complete no and complete yes. Complete no, wholly state, complete yes, established by trust. Now there is a partial yes with consent, because these are already religious ones. Therefore, they have certain right, they can go for it. But when partially, because it is aided by state and controlled by state, so there is a issue of consent here. Understood? So these are the 4 types of institutions, and what is the specific issues within the 4 types of institution with regard to imparting the religious instruction and the right and the freedom of attending such instructions, religious instructions. That is not important, syllabus and वो सब चीज़ें हैं, but not important for us. Okay. केवल words याद रखो. Okay. Aided is a funded, controlled is regulation. Second one में funding वो complete वही है, private. Okay. It is only the administration will be looked into. ठीक है. Funding देखो यहाँ पे aiding मतलब that is a funding. Is that fine? Okay, so 25, 26, 27. 25 is the individual freedom, 4 freedom, conscience, profess, practice and propagation. That is 25. 26 is a group freedom. Group freedom, that is the establishment of the institution, administration of institution. Is acquisition of property and administration of property. Administration of property by law. Regulation of property by law. 27, freedom to payment of taxes, which can be used only for the one particular religion, that is avoided. And 27 is about freedom from religious from attending in the schools. Now come to the 29 and 30, last 29 and 30. See, you have to mug it up, मतलब थोड़ा सा 3-4 बार पढ़ोगे तो there won't be any issue. Okay, just have to remember Article 29 and Article 30. Article 29 and Article 30. These are now the name, again this is a fifth variant. Fifth variant का नाम क्या है? Cultural and educational rights. Cultural and educational rights. Basically, generally we tend to see that these are the minority rights. Okay, I'll say that, but what is the difference I'll also tell. Minority rights, because cultural and educational minority rights related यहाँ पे provisions हैं. So let's see what is Article 29 saying. 29 saying that any kind of particular group, they can maintain 3 things. Language, मतलब right to preserve. Right to preserve 3. LANGUAGE, language, script and culture. These are the 3 things. It means that if you are a minority language, this is a freedom granted to you. But remember that the word minority has not been mentioned. Therefore, even the majority, उनको भी right है ये language, script and culture का. But majority के लिए वो तो रहेगा ही रहेगा. मतलब by default, yes, it is not getting destroyed. So it is more specific significance for minority. But constitution nowhere mentioned it is only for the minority. Are you understanding? More importance is for the minority because there is always a threat for language, script and the culture. But it is for both. Understood? This much is only written in 29 clause 1 that you have right to preserve language, script and culture. And second is within 29 only, there will not be discrimination. Something like Article 15 में हमने किया था. There will not be any discrimination on the in admission to there will not be discrimination in admission to educational institutes on the basis of four criteria. That is race, religion, caste and color. No, language. This is important because rest are quite similar. Okay, that of the 15. Let me see that what are the different bases for discrimination. Article 15 में कौन सा discrimination था? How many bases? 6 नहीं है, 5 हाँ 5. 6 भी हो जाता है any other करके अगर ऐसे दिखाएं. 5 कौन सा है? Race, religion, caste, sex and place of birth. Sex and birth. Article 16 में कौन से discrimination है? Yes, ये 5 plus 2. 2 कौन से? Yes, residence and descent. Article 29 में कौन सा discrimination है? This. There are 4. There is no sex also, place of birth also. Because we can understand that वो जो co-ed school or girls school sort of things. Okay. So here the discrimination, you cannot discriminate on the basis of race, religion, caste. Notable is language. Language we haven't seen so far any time. So because it is about the cultural minority. Matlab you cannot deny admission to the educational institution saying that you belong to a particular minority language. You cannot say so. Okay, or minority religion. But ये चार चीजें. So Article 29 में 4 criterias. That is a race, religion, caste and language. Article 29 is about 2. One is about the preservation of the language, script and culture, and it is about not discriminating on the basis of 4 criteria in admission to educational institute. Okay? Now let's come to within this there is a second article, that is Article 30. Now see, the thing is that Article 30 explicitly mentioned this is the only right of minorities. Minorities will. यहाँ पे the word minority is nowhere mentioned, as I have already said. Okay, although this is significant for minority because there is always a threat to the minority culture, minority script and minority language. But Article 29 extend to all the people. Okay, whether they are minority or majority. Article 30 explicitly it is about minority. Now what is the minority right here with regard to establishment of educational institute? Minority will have right to establish and administer educational institutes. Okay, establish and this thing, educational institutes. Okay, so it is a completely the right of minorities, minorities to have an educational institute of their choice. Now, there is something related with the right to property. Otherwise, right to property is not a fundamental right, first point. Second is for the religion, group right ke under, yes, they can have the property, but it can be regulated by law. They can. Also, individual religion cannot. Okay, group religion can acquire the property. Now, there is also here something related with the property. Say, for example, there is a educational institute established by minority. Okay. Now, if since it is not a fundamental right, only religious का group right के लिए property right है. Okay, यहाँ पे if there is a need for state to acquire this property, let us assume that they have acquired this educational institute's property. Okay. Yes. No, state can acquire. State can acquire. Compulsory compensation has to be provided. Okay. So state can. This compulsory compensation provision is not there for the individual acquisition of property. अगर आपकी property है और compulsory acquire कर रहा है state, so there is no fundamental right. Okay. You can have the legal and the ordinary way to go about it. कि आपके लिए compensation है, but that's not your fundamental right if the state is acquiring the property. But here, if the property of minority educational institution is being acquired, You can acquire, state can acquire, but they have to provide the compensation. That this एक issue आप याद रखो, okay? That is, they have to compulsorily give the compensation. Understood? Okay, so this is about the Article 29 and 30. Okay, 29 is related with language, script and culture and no discrimination, and 30 is related with minority educational institutions. They can establish and administer minority educational institutions, and in case of acquisition, compulsory acquisition by the state, the compensation has to be provided, and this compensation has to be provided is written within the fundamental right, that is part 3. In case of individual, if the compulsory acquisition is there, that compensation clause and anything of that sort is not there. So 2 exceptions याद रखो, that is a religion में property rights are granted to the religious denomination, and second exception is if minority educational institutions are acquired, compensation has to be provided. Yes, minority is not defined in. Yes, there are religious minorities and linguistic minorities, and in one of the court's judgment they have said that 50% will be the criteria. So as per that, at a national level, there are 6 religion. Okay, that is a, yes. Recent addition is a Jain. Initially there were only 5. Parsi is there. Muslims, Sikh, then Buddhist, Jain, Christian, and Zoroastrian and Parsian. Zoroastrian or Parsi. Now this is 1, 2, 3, 4, 5, 6. Recent addition is Jain. Now who are asking for the minorities? Is Jews का क्या है? There are there, but there is a demand going on, but now they are saying let's, मतलब already the prosperous community and these aspects are there. Okay, but yes, as of now this, at a state level, it will depend upon the regional criteria. Okay, that is a 50% criteria. So by that criteria, Hindus are also minority. In which of the states? Northeast, हाँ Northeast 9 states है. मेघालय नहीं है. अच्छा आप पूछ रहे हो, मतलब ये क्विज चल रही है. अरे पहले का जम्मू एंड कश्मीर फर्स्ट. ओके, जम्मू एंड कश्मीर, पंजाब सेकेंड, थर्ड इज नागालैंड, मणिपुर एंड मिजोरम 5. ठीक है, नंबर वाइज. बट देर इज अ लॉट ऑफ डिबेट, मतलब ये कुछ टेक्निकल डेफिनेशन नहीं है. देर इज अ ग्रे एरिया. Okay, one of the Supreme Court judgment has said, but yes, there was a committee called as Ranganath Mishra Committee. Ranganath Mishra Committee has suggested, okay, we have to go for the new criteria. So just for the sake of one of the court's decision is this. Otherwise, if the question is asked, who are the minorities are not defined in the constitution. Okay? That's only for the practical purpose, it's there. In fact, there are many debates whether the Stephens College in Delhi is a minority institution or not, whether the university कौन सी है यहाँ की, जामिया मिलिया is a minority. तो काफ़ी सारे बहुत सारे debates है. Okay, we will not go into Aligarh Muslim University and so on and so forth. Okay, that's a main part, but remember these 2 clauses. Okay, now let us come to Article 31 and 32. We'll finish then. Article 31, one of the very confusing article, but it's not that confusing if you keep it simple. नहीं, Article 32 कर लेते हैं पहले. Fundamental right है, because 31 is a exception, is not a fundamental right. Article 32 is that is last article, that is 6th constitutional remedy. Constitutional remedy. Constitutional remedy, as the word suggestive of remedy. Remedy मतलब जो भी fundamental right है, अभी तक जो हमने देखे 5 fundamental rights, 5 categories of fundamental rights. There are no 5 rights. 5 categories. Remember this word, that is 5 categories of rights. 5 categories of fundamental rights. This will not have any significance if you don't have provision for enforcement. Okay. So Article 32 will give us a chance that if the fundamental rights are violated, then you can go to the Supreme Court for its enforcement. Okay. So right of constitutional remedy means it is your fundamental right that you can go to the Supreme Court for the enforcement. So we will see that what are the clauses. First, that right to move to Supreme Court. Right to move to Supreme Court for enforcement of fundamental right. So this is right for individual. Right for individual to move to the Supreme Court. Second, अब सुप्रीम कोर्ट में जाने के बाद सुप्रीम कोर्ट क्या करता है? नेचुरल मतलब करोलरी इसकी, आप सुप्रीम कोर्ट में चले गए तो सुप्रीम कोर्ट विल टेक द एक्शन फॉर एनफोर्समेंट. इट विल हेल्प. इट विल रिलीज 5 writs. They will release the 5 writs. We will discuss about it in a short while. So 5 writs in order to enforce your fundamental rights. 5 writs to enforce fundamental rights. Yesterday I have explained that there has to be a violation of fundamental rights. आपको कुछ एक evidence लेके जाना पड़ेगा, ऐसे नहीं कि मुझे feel नहीं हो रहा है etc. Okay. There has to be a certain violation. Okay. So right to move for individual, Supreme Court will issue the 5 writs. I am not writing High Court. Why? Yes, it is not 32. We are only discussing 32. We are not discussing writs. We are discussing Article 32. Third is very important. Many times question is asked on this. Okay. Parliament has power. Remember, do not forget this. Many times this is added in different statements. Parliament has power to empower any court. To empower any court. Okay. This with the writs. Power to issue the writs. Any court power to issue writs. Now there are 2 things here. Any court does not include High Court because High Court has already have the power. It means that any court means subordinate court they are referring. District courts and session courts and municipal courts and family courts etc. मतलब district level के ऊपर. Because High Court is already given the power, that is 226 के अंदर power दी गई है. So in future it is quite possible. Today writs can be issued only by Supreme Court and High Court. This is under 32, this is under 226. As of today only these 2 courts, but in future again it is the only parliament. Remember, state will not have for their respective this thing, only parliament. Again without any prejudice to सुप्रीम कोर्ट पावर, मतलब ये इंटेंशन नहीं है कि सुप्रीम कोर्ट की पावर काट के इनकी पावर देनी है. ओके, कंकरेंट पावर विल बी देयर, बट पार्लियामेंट हैज नॉट सो फार टेकन एनी डिसीजन. सो एज ऑफ नाउ पार्लियामेंट हैज नॉट एम्पावर्ड एनी कोर्ट. ओके, इन एडिशन टू मतलब सुप्रीम कोर्ट हाई कोर्ट जो है, तो ऑब्वियसली टुडे दिस आर्टिकल इज देयर. इन फ्यूचर पार्लियामेंट कैन एम्पावर, but today it's only about Supreme Court and High Court. Understood? So this is about this thing. And fourth, yes, what is the fourth clause? Fourth related क्या है? हाँ, yes, that is yes, Article 32 will not be suspended एक्सेप्ट जो भी प्रोविजन है कॉन्स्टिट्यूशन का, वो हमने देखा है क्या है, नेशनल इमरजेंसी. ओके, व्हेन आर्टिकल सस्पेंडेड यस्टरडे मैंने कहा था, दैट इज नेशनल इमरजेंसी. विच आर्टिकल इज ऑटोमेटिकली सस्पेंडेड? 19. ओके, आर्टिकल 19 इज ऑटोमेटिकली सस्पेंडेड and it is suspended full length of time, but only in 2 specific cases of national emergency. That is, if the national emergency by external aggression and war, not in case of armed rebellion. Okay, and automatic suspension. अब 32 और कौन से आर्टिकल है फंडामेंटल राइट्स विच कैनॉट बी सस्पेंडेड एट ऑल? 20 and 21, okay, which cannot be suspended at all. 19 automatically suspended and 20 and 21 can never be suspended. Now 19 छोड़ के और कौन से आर्टिकल सस्पेंड करने, तो आपको ऑटोमेटिक नहीं होगा, प्रेसिडेंट, yes, presidential order. So under the presidential order in national emergency, maybe 32 can be suspended, not otherwise. Okay, there is no other any chance. So this is also written. So even if it is not written here, we already know that through the national emergency such thing happen. Okay, this is basically under article 359, नहीं 358 के अंदर होता है. 359, 358 is for automatic suspension of 19. This is under article 358. Okay, we will see it in national emergency. ये important नहीं है, समझो ये repeat होगा, but ये तो हमें वैसे ही पता है कि we can move to the Supreme Court and Supreme Court give 5 writs. This is important article which can be missed. That is, Parliament has a power. Now we will very briefly see what is the writs, what are the 5 writs, and what are their exceptions. Five writs. First, remember that these writs are issues in order to enforce fundamental rights. This is to enforce the fundamental rights. Now, there are 5 categories of writs. That is, first is, yes, habeas. Just see the spelling. Confirm कर लेना. Okay, ठीक है. Habeas corpus. Second, mandamus. Mandamus. Third is prohibition. Fourth is certiorari. And fifth is, yes, quo warranto. Not very difficult if you remember the literal meaning of it. अपने आप से याद रह जाएगा. Okay. Although seems to be थोड़ा सा 1-2 बार revision चाहिए. Yes, this is again one of the area where match the pairs and some kind of things they ask. Either they ask match the pairs, that is the simplest one, because then it is very superficial. Second, they can pick up habeas corpus या कोई भी एक और उसके अंदर 2 statements देंगे. इसके लिए नहीं है types. ठीक है? So first, habeas corpus. What is the literal meaning of it? To have body. To have body of. Now remember which kind of fundamental rights they are enforcing. This is a fundamental rights against the arbitrary detention. मतलब आपको किसी ने detain किया है, which is a illegal detention. So obviously, you know that you have been arrested for non-legal, non-constitutional reason. So obviously your arrest is arbitrary arrest. You can go to the Supreme Court and ask for this particular thing. So Supreme Court will issue the habeas corpus, that is to have the body of. So what is the protection here I am writing? What is the protection that has been given under the habeas corpus? Protection is protection against arbitrary detention, arbitrary arrest or detention. So court will, what it will do, court will ask that to have the body of, that you bring this person who has been arrested. So court is asking, that is to have the body of. So the person who has been arrested will come in front of the court, and court will see the legality of such arrest or detention. अगर legal detention है, okay, genuine detention hai, so court will say that it's fine. And if it is not, then it will release you. It means that habeas corpus will ensure, ऐसे नहीं है कि आपको जेल से छोड़ दिया जाएगा. The word is arbitrary detention will be protected. If it is a legal detention, तो कौन से detention है जो legal आ सकते हैं, जिसमें detention is fine. Yes, preventive detention and all that. That is a court ने मतलब बताया है आपको. Okay, because of contempt of court, contempt of legislation, your particular detention is because of court of law के order के court ने बताया कि इसको detain करना है. So obviously it is not an illegal detention. You have gone into the detention because of contempt of legislature, contempt of court. So such kind of detention are, yes, legal detention. And this detention is, yes, it is not only against the state, but it is against the private person also. Okay, remember this. This is one thing where the protection is not extended only to the state but also to the private person. It means that it's not about the state has detained you. It can be possible that an individual person has been detained you. So in that category, this right extend to the person. So no person can be, in otherwise, no person can be detained without something which is a legal. Okay, that is again establishment of rule of law. Okay, habeas corpus will give prevent this thing. Mandamus. What is the literal meaning of mandamus? Huh? To command. Huh? We command, we order. We command or we order. Now, this is, we are ordering someone. Okay, कि आप ये करो. मतलब do this thing. We are simply saying do this. We are commanding. It means that somebody must not be doing something. Somebody must be inactive, passive. So when it happens, and what is the protection that is given here in case of mandamus, that whenever any government functionary, office, legal office, institution, court is not functioning, okay, is not functioning or not carrying out their duties, etc., etc. So there is an inactivity on their part. So you can go for the asking for the enforcement of fundamental rights through the mandamus. Through the mandamus, okay, the higher authority will issue the mandamus to the lower authority in order to make ask them to do something, okay, to carry out whatever the things which is not being done. Inactivity se activity aa gayi hai. Are you understanding? So this is a protection for carrying out certain things and enforcement of certain things by the higher authority to the lower authority. Remember that, जैसे यहाँ पे लिखा हुआ है, this is for the state and personal private person. It is not only for the courts, from lower court to higher court. It can be for any authority. Okay, it can be administrative authorities. It can be legal or court. मतलब any kind of the government, within the government, it can be issued from the higher to the lower, be it administrative, be it any kind of institutional hierarchy, or be it a court hierarchy. Any upper hierarchy can issue the mandamus to the lower hierarchy. Understood this point? Okay, this is for the activity to do this. Prohibition. Prohibition का literal meaning क्या है? To prohibit or to stop. See, this is exactly opposite of this. यहाँ पे क्या बोल रहे हैं? ये आप करो, और यहाँ पे बोल रहे हैं कि don't do it. Okay, do it. यहाँ पे हम बोल रहे हैं कि do it. यहाँ पे बोल रहे हैं don't do it. Now, do it क्यों बोल रहे थे? क्योंकि वो नहीं कर रहे थे. There was an inactivity. Don't do it because of two reasons. It can be possible, or say for example that yes, you have to, yes, the jurisdiction utna nahi hai, so therefore you are asking them not to do it because your jurisdiction is not there. Remember that second difference. पहला तो difference तो एक simple है कि यहाँ पे to do something, यहाँ पे to avoid something. Second difference is this can be, the mandamus is for the judicial purpose and non-judicial purpose, but prohibition is only for judiciary. It means that prohibition is only by the higher court to high court नहीं है, higher court to lower court. मतलब it can be Supreme Court to high court to subordinate court. So from the higher judiciary to lower judiciary. So it is only a judiciary. So there are two differences between the mandamus and prohibition. Mandamus is asking you to do something, whereas prohibition is preventing you from doing something. Mandamus is for judicial and all non-judicial institutions, whereas prohibition is only for the judicial institutions. Understood? Okay. Now the certiorari. Certiorari is to certify or to inform. To certify or to inform. Now, this again certiorari has to be compared with prohibition. There is a, see, the prohibition is something which has not yet happened. You are preventing it from happening. So it means that you cannot cure here. Okay, cure के लिए नहीं है. This is only to stop something which has yet to happen. Here it is for both. It can be, yes, preventive as well as curative. I'll explain that what it is. Preventive as well as curative. Say for example, preventive to something exactly similar to prohibition. Okay, you can ask the lower court, please give that particular pending case to us. So you are asking them to prevent from happening. But say for example, the lower court has already gone ahead and done something which to which you are not happy. So you have not able to prevent it, but now you can cure. Cure matlab quashing the orders. You can quash the orders now. Are you understanding? Something, a wrong decision has been taken by the lower court. Okay, so which may have an element of error. Okay, they have already taken the decision, which may have the element of error. Now what you can do is you can cure. So this is issued by again higher court or higher judiciary to lower judiciary, not only to prevent but also to cure the orders. But remember, recently it was only with respect to judiciary only. It was only with respect to judiciary initially, but now it has been also added to administration. Okay, recently it has been also added to administration. It means that higher administration can issue the certiorari for the lower administration, and they can prevent also and they can cure also. It means that, say for example, yes, SDM है, SDM ने कुछ decision लिया है, administrative decision. A collector, very crudely बता रहा हूँ, okay, collector might can issue the certiorari in order to quash the order of SDM. Are you understanding? Initially it was not. Initially it was only related with the courts, that the high court will quash the order of the lower court. Now it has extended to administration. It means that higher administration also can quash the order of lower court. But remember, certiorari is only extended to judiciary and administration. Prohibition is still only within the judiciary. Prevention is not there for the administrative aspect. It means that the court collector has to wait what the SDM is going to take the decision. He cannot prevent, he cannot say that no, take it to me. Here it can be possible for the high court to ask them even before the taking of decision. Understood? So the difference between mandamus and prohibition and certiorari. Mandamus and prohibition, one is for doing, one is for not doing, one is for all the things, and one is related with judiciary. Last is quo warranto. What is the literal meaning of quo warranto? By what authority? It is questioning the authority of a person who has occupied the constitutional or legal post. Okay, constitutional and legal post. So it means that it is preventing, it is a protection that government institutions created by the constitution and by the legal statute will not be arbitrarily taken up. ओके ऐसे नहीं है कि कोई भी टॉम डिक हेरी वहां पे जाके बैठ गया और बोल गया कि मैं आज से पंतप्रधान बन गया हूं या मैं आज से आपका राष्ट्रपति हूं. Okay, so the court will question under the quo warranto. By what authority? So in a way they are trying to protect constitutional bodies or constitutional post or the legal post from usurping समझ रहे हो, usurping the power or taking up the power by the despotic rule. Okay, even if he is not having a qualification, he has not been nominated, elected, so court will ask the authority. But remember that this quo warranto is not applied for the positions which are private position and the discretionary position and other nature. There has to be two. One is such post is created by constitution or such post is created by statute. Okay, it is only for this thing. So that is about the quo warranto. So what you have to remember is what it is, to whom it is applied and to whom it is not applied. Okay, many times questions are asked, but not too much of detail, but superficially you should remember. हाँ. Preventive कौन सा? This preventive. नहीं, preventive भी है उसमें. सर्श्योराय में नहीं, नॉट नेसेसरीली डिसीजन अभी पेंडिंग ही है, तब भी सर्श्योराय में आप सर्टिफाई करके, हाँ सही सेम है, लेकिन इसमें ऐड है। नहीं नहीं, उल्टा नहीं है, यही है। नहीं, यहाँ पे फोकस तो क्यूरेटिव के ऊपर ही है। सी द थिंग इज दैट, अच्छा उल्टा मतलब प्रेफरेंस फॉर समवन, ओके। नहीं नहीं, क्यूरेटिव और प्रिवेंटिव बोथ आर देयर। प्रिवेंटिव अभी डिसीजन अगर नहीं हुआ है तो भी सर्च मतलब दो जगह पे यूज हो सकता है, प्रोहिबिशन भी कर सकते हो आप, और सर्श्योराय के थ्रू भी आप किसी को स्टॉप फ्रॉम टेकिंग द डिसीजन, ठीक है। ये ऐसे समझ लो कि प्रोहिबिशन अगर आपको करना है तो यू हैव द टू टूल्स विथ यू, यू कैन आइदर यूज द टूल ऑफ प्रोहिबिशन और सर्श्योराय, बट इफ द डिसीजन इज ऑलरेडी टेकन यू कैन यूज ओनली वन टूल, दैट इज अ सर्श्योराय, ठीक है। अंडरस्टूड दिस पार्ट, बट इन एनी केस यहाँ पे जुडिशरी है और यहाँ पे जुडिशियल एंड एडमिनिस्ट्रेशन है, ठीक है। नाउ द लास्ट इज स्लाइटली अ डिफरेंस, आई विल नॉट राइट हियर, ओके, एक्सप्लेन इट। Difference between the writ jurisdiction of the High Court and the Supreme Court. See, in case of a territory, if you compare with the territorial application, then obviously Supreme Court is high because it's the whole country, it can issue the jurisdiction. But High Court can issue the jurisdiction only if such matter is coming, violation of fundamental rights is coming within that particular territory of the High Court. So that's the territorial jurisdiction. So Supreme Court is higher than the high courts. In case of different issues that are to be issued, it's the High Court which has the upper hand, because High Court can issue, yes, there is writs not only for the fundamental rights but also for ordinary legal rights also. So they can issue these 5 writs also for the non-fundamental rights, but under Article 32 Supreme Court can only issue for the fundamental rights. That's the second difference. Third difference is, yes, 32 is in itself is a fundamental right. So Supreme Court cannot deny, because it is a fundamental right in itself. Constitutional remedy is a fundamental right. So Supreme Court cannot deny. High Court in 226 may or may not. Matlab it is there. That they may issue or may not issue, they can deny. Understood? These are the 3 aspects. Because 32 is a part of fundamental rights and it can be issued writs, therefore Supreme Court is called as constitutional guarantor and defender of fundamental right. See, the thing is that if this will be there, guarantor and defender of fundamental right is High Court, Supreme Court, both and none, what will be the answer? Yes, only Supreme Court, okay, because that technical word is because 32 is a part of fundamental right, ठीक है। Otherwise, if it is about the writs are used for the fundamental rights enforcement, but this is only for the Supreme Court because 32 is a fundamental right. Now, I'll just discuss very briefly 31. That is last, basically. Rest of the rights you can, in fact, we have finished all the 6 categories of rights. That is 31 we will discuss. This is a small table type thing. You can remember this way. It's not very difficult. 31 is related with the exceptions, or in certain circumstances how there is a overriding of fundamental rights. So fundamental rights are overridden in certain cases. Overriding समझ में आ रहा है? So there are, it means that in 3 circumstances fundamental rights can be taken away, or the remedy is not, sorry, 31B and 31C, 31A, 31B and 31C. So I am writing here in which cases, and here I am writing which fundamental rights, and then I am writing some notes, okay, some special notes regarding it, okay. So what is Article 31? Article 31 में there are 5 categories of laws. You don't have to remember which categories, just remember 5 categories of laws are there, and these laws are related with the agricultural reforms and land acquisition. Okay, agricultural reforms or the land acquisition reforms, zamindari वगैरह ये reforms है. So there are 5 categories of law. It means that if the parliament or the state will make the laws on that subject, they can, okay, the right which is not available fundamental is Article 14 and Article 19. 14 and 19. It means that you can make the law even if you are violating the Article 14 and 19, and you cannot go to court in challenging these laws. Are you understanding? 5 समझ में नहीं आया? Yes. See, the thing is that generally क्या होता है, whenever parliament and state makes the law, okay, there is a called as judicial review. Judicial review will happen on the basis of fundamental rights. If a particular law violates the fundamental rights, then to that extent of contravention, it will be considered as null and void. But such law, now let us assume that Parliament has passed the law on these 5 matters. 5 matters related with land acquisition and these things. Such 5 matters, there will not be a judicial review, or you can say that judiciary will not struck down that it has violated the 14 and 19. It means that these kind of the laws has a upper hand as compared to Article 14 and 19. There is one, अब notes में क्या लिख रहा हूँ कि such laws which are passed should be reserved for president, and president has given its assent. It means that these are, see, if any kind of a law which is trying to take away the fundamental rights and you cannot challenge, so there has to be certain procedure. Okay, पहले तो आप law pass करो. Such law has to be reserved for a president, and president must have given the assent. It means that there is a lot of significance, because why it is important? Because state may pass the law, okay, as per their whims and fancies, which may not be a part of 5 types. मतलब थोड़ा बहुत कुछ मैनेज करके 5 टाइप्स में बिठा के कर रहे होंगे, तो एटलीस्ट प्रेसिडेंट के पास जा रहा है, मतलब yes, these are in the 5 categories and it has got the assent. So in such cases 14 and 19 can be violated, or remedy, constitutional remedy for the violation of these particular laws is not available under 14 and 19. I hope the point is clear. Okay, 5 categories of law. Yes, anybody who has not understood, have you understood, everybody? Okay, now 13b talks about 9th schedule. Okay, it's talk about the laws which are placed in 9th schedule. Laws, I'll explain that. मतलब इसमें कोई भी law होता है, 5 category of law नहीं है. Any kind of the law you have passed and then you have put into the sack. Yesterday I have explained there is a 9th schedule, sack is there. You put it into the 9th schedule, then any fundamental right, you cannot challenge on the basis of any fundamental right if it is placed in 9th schedule. Understood? So it means that a 9th schedule is a sort of a place where judicial review is not available on any fundamental right. So the scope of law is more, कहाँ पे है? यहाँ पे है, क्योंकि यहाँ पे any law है, यहाँ पे only 5 categories of law. So यहाँ पे any law है. Scope is broader here also, because here only 14 and 19. It means you can challenge these 5 categories of law on rest of the fundamental rights. But once you have put it into the 9th schedule, you cannot challenge at all on the basis of any fundamental rights. Notes में क्या लिखना है? Notes में ये पहले की situation थी, okay? After Keshwanand Bharati and this thing, today court has said that okay, you put into the 9th schedule, we will not mind it. Okay, we will not go for the judicial review also until and unless it violates the basic structure. So yes, judicial review is available, okay, on the grounds of basic structure. on the grounds of basic structure. But इसमें ये है कि पहले जो लॉ पुटअप किए हैं ऑन द डेट ऑफ 24th ऑफ अप्रैल 1973, इसके पहले जो लॉ 9 शेड्यूल में रखे गए उसका जुडिशियल रिव्यू नहीं होगा, बिकॉज दिस इज द डेट फॉर केशवानंद भारती केस. So Keshwananda Bharati case has established the basic structure doctrine. So there will not be a retrospective effect on the 9th schedule that अब ये basic structure देख के फिर टॉर्च लगाएंगे कि कहाँ कहाँ आपने वायलेट किया था, सब स्ट्रक डाउन करेंगे, तो काफ़ी सारे स्ट्रक डाउन हो जाएंगे, तो वो नहीं होंगे. Only after this date, whatever the law that have been put, it will be go through the basic structure. Understood? So scope has been little bit curtailed as compared to, नहीं तो पहले एकदम क्या था कि because Supreme Court has said that you have taken 100% judicial review. Judicial review is a basic, otherwise is a basic structure. Separation of power का part है, so obviously this is there. Understood? Now come to the 13C. 13C में कौन सा law है जिसको protection मिलता है? If any law which is trying to implement Directive Principle 39B and C, Directive Principle of State Policy, DPSP, total DPSP नहीं है, okay? Only 39B and C. 39B and C clause is related with no concentration of property and equitable distribution of yes material for the society. मतलब ये socialist principle है 39B and C. If a law is made under 39B and C, such law will not be challenged. Again, Article 14 and 19. Okay, it means that यहाँ पे there is a one directive principle which is having a upper hand over the two fundamental rights. Understood? There is a one directive principle which is having a upper hand over the two fundamental rights. This cannot be challenged. ओके नोट्स में मैं कुछ लिखने वाला हूँ. नोट्स में ये है कि दिस हैज़ बीन एडेड बाय 42nd नहीं सॉरी 24th नहीं 25th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. 25th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट हैज़ एडेड दिस 31C मतलब आई एम राइटिंग हियर 39B and C is having an upper hand over Article 14 and 19. समझ में आ रहा है ये? All of you have understood. Now थोड़ा सा इसके ऊपर और enthusiasm हो गया कि चलो हमें एक तो राइट मिल गया B and C का. Later on in 42nd constitutional amendment, they have extended कि all DPSP, it's not 39B and C, all directive principle, अगर हम लॉ बना रहे हैं in order to implement all directive principle, then it cannot be challenged on the basis of this. Okay, इसको बढ़ा दिया गया. But I am not writing there because it has been later struck down. Okay, Minerva Mill case में उन्होंने बोला you are तो trying to create a situation that directive principle are superior than the fundamental right. So 42nd में क्या हुआ था, ये जो extension था केवल एक directive principle को, this got extended to all directive principles. All directive principles are greater than 14 and 19, which has been later struck down by Minerva Mill case. Okay, Minerva Mill case. तो इन्होंने ये जो है कि no, you cannot extend to all directive principle. It has reinstated this position. Okay, that is, it can be only through the 39B and C. Understood? So Minerva Mill case के बाद जो final position है, final position यही है. 39B and C will have an upper hand over the 14 and C. So remember that 31 is about protection for 5 categories of laws. 39B is a protection for 9th schedule, and 31C is for the protection of one directive principle, that is 39B and C. 5 categories of law against 2 fundamental rights, 9th schedule for any fundamental right, and 39BC again 2 categories of rights. Such laws should be reserved. 5 categories of right है तो आपको ऐसे law मतलब reserve करे होगे तभी मिलेगा. Also इसमें है कि see, one is there, since these are all the land acquisition related rights, मतलब property right acquire करने वाले राइट से एंड यू कैन नॉट क्लेम द प्रॉपर्टी। लेकिन आपकी जो लैंड है अगर सीलिंग लिमिट के अंदर थी, are you understanding, there is a surplus land also, so the surplus land if it is acquired there is no compulsory compensation that has to be given, but if your land was ceiling limit जो भी है, मतलब say for example just crudely ले रहा हूँ 2.5 एकड़ सीलिंग है हेक्टर, अगर आपकी लैंड उतनी ही थी 2 हेक्टर लैंड थी, वो कंपलसरी लैंड भी एक्वायर कर लिया, तो इस कैटेगरी ऑफ केसेस में कंपलसरी कॉम्पेंसेशन देना पड़ता है। सो कॉम्पेंसेशन इज गिवन इन 2 एरियाज व्हेन एजुकेशनल इंस्टीट्यूशंस ऑफ माइनॉरिटीज। ओके, कौन सा आर्टिकल था? 30? यस यस, 29 नहीं है, 30 है। माइनॉरिटी एजुकेशनल इंस्टीट्यूशंस की अगर प्रॉपर्टी एक्वायर की कंपलसरी कॉम्पेंसेशन है, और इंडिविजुअल ये इसके अंडर 31B के अंडर अगर आपकी सीलिंग के अंडर है तब भी कॉम्पेंसेशन मिलेगा। एनीवेज इवन इफ यू विल नॉट रिमेंबर इट विल नॉट हैपन एनीथिंग, जस्ट अ सेकंड। इन दिस केस 9th schedule the final you can say that judicial review is available provided that basic structure doctrine has to be applied. इसमें एक थोड़ा था, आई विल नॉट ऐड इट, जब 25th कॉन्स्टिट्यूशनल अमेंडमेंट में ये ऐड किया था कि 39B and C such laws will not be challenged under 14 and 19, उसमें एक सेकंड सब क्लॉज भी ऐड किया था, वेरी इंटरेस्टिंग क्लॉज। पहले तो हम ऐसा लॉ बनाएंगे 39B and C को मतलब इम्प्लीमेंट करने के लिए, एंड यू कैन नॉट चैलेंज दिस, बट देन यू ऑल्सो शुड नॉट चैलेंज अस कि हमने जो लॉ बनाया है वो 39B and C को सही में इम्प्लीमेंट करता है नहीं है। ट्राई एंड अंडरस्टैंड। First clause is saying we will make a law which will implement 39B and C. Okay, एक clause है, we will make a law in order to implement 39B and C, and you will not challenge this under the article 14 and 19. ये एक clause था। दूसरा clause था कि do not even question this कि our law will not implement 39B and C, मतलब ये भी क्वेश्चन करो मत करो बोल रहे। तो सुप्रीम कोर्ट ने इसको हटा दिया। अरे ये क्या मतलब आप कहना है आपका, एटलीस्ट ये तो रखो कि आप इम्प्लीमेंट कर रहे हो और चैलेंज नहीं करते हो। तो इसका जो यहाँ पे था तो 42nd अमेंडमेंट के अंदर है, वो इंपॉर्टेंट नहीं है बिकॉज इट हैज बीन स्क्रैप्ड ऑलरेडी, इट हैज बीन स्क्रैप्ड ऑलरेडी, दैट इज not important, this is important, final position is this. I hope the exceptions are clear. Okay, remember this way because otherwise there are lot many confusions. Okay, this was extended but not, it has been scrapped down. So this is regarding the exception. See, there are 3 articles which you can read it from Lakshmikant. There is nothing to discuss because fundamental rights are over 32. There is a 33, 34 and 35. What is 33? Yes, 33 is regarding curtailing the fundamental right for the military and paramilitary forces. Okay, so you can read it what the parliament provisions. Okay, एक छोटा सा मतलब 3-4 लाइन का provision है, ज़्यादा नहीं है। 34 is martial law and 35 we have already discussed. जहाँ पे भी लिखा था ना कि parliament may by law, parliament may by law, तो उसको collect किया है उसमें 35 में। These are not as such a fundamental rights, these are provision within the part 3 only. These are exception. 33 is exception कि फंडामेंटल राइट कर्टेल कैसे की जाते हैं। आप आर्मी में हो, आप रॉ में हो, आईबी में हो, पैरामिलिट्री फोर्सेस में हो, तो ये सब राइट्स नहीं अवेलेबल होंगे, उसको कर्टेल किया जाएगा। ओके, एंड देन मार्शल लॉ क्या है एंड दिस थिंग। ओके, अदरवाइज आई कैन इन सम अनदर क्लास आई कैन एक्सप्लेन दैट। व्हाट वी हैव टू डू नाउ is shall I take some 15-20 minutes more? From yesterday's class. Okay, ये तो अब कल ही करेंगे query because we have run out of time. ये करना है इसको नहीं, we can finish directive principle. See, the article we need not have to go into detail. I'll just explain the philosophy of, because directive principles, there is no clause, there is no discussion, there is nothing. You just have to mug it up. I'll just give you the brief account of directive principle and fundamental duties. 15 minutes maximum it will take. 15-20 minutes, huh? Is that fine? Kya? 5 minutes ब्रेक चाहिए क्या? वी कैन कंटिन्यू. क्रैश कोर्स है, हाँ ये क्रैश कोर्स है तो ऐसे ही. अच्छा क्रैश हो गया, ओके.
सर वो 31A जो है वो फंडामेंटल राइट है?
नहीं नहीं, वो एक्सेप्शन टू.
वो जो एग्रीकल्चर वाला, अगर मेरा सीलिंग से कम है, मैंने से ले लिया,
हाँ यस
तो मैं जा सकता हूँ?
यस. अच्छा 39B क्यों प्रॉब्लम होना चाहिए? 39B इज टू गिव द प्रोटेक्शन टू द 9th शेड्यूल. शेड्यूल पता है 1 to 12 शेड्यूल है. हाँ अच्छा 39B and C. ओके ओके प्रोविजंस. ओके 39B and C I'll explain. अभी वैसे डायरेक्टिव प्रिंसिपल ही करने वाले थे लेकिन बता देता हूँ. उसमें ABCD है, कितना है? 1 2 3 4 5, हाँ F तक है, 6 है. ठीक है. एनीवेज यहाँ पे B and C के ये है. B में ये लिखा हुआ है कि इक्विटेबल डिस्ट्रीब्यूशन ऑफ वेल्थ, मटेरियल रिसोर्सेस. इक्विटेबल डिस्ट्रीब्यूशन ऑफ मटेरियल रिसोर्सेस. Equitable distribution of material resources in order to create the obviously the equality egalitarian society. और इसको भी इसी को लिखा है अलग ढंग में, that is in negative sense लिखा हुआ है. There will be no concentration of property and wealth. दोनों का मीनिंग वही है. ये नेगेटिव कैनोटेशन है. देयर विल बी नो कॉन्सेंट्रेशन ऑफ प्रॉपर्टी को, या फिर बोलो कि द प्रॉपर्टी एंड द मटेरियल रिसोर्सेज शुड बी इक्वली डिस्ट्रीब्यूटेड. इनफैक्ट दीज आर टू, दैट इज जो मार्क्सिज्म और सोशलिज्म के जो बेसिक टेनेंट्स है, दैट इज देयर शुड बी नो प्राइवेट कॉन्सेंट्रेशन ऑफ प्रॉपर्टी, देयर शुड बी कम्युनिटी ओनरशिप. एंड हियर ओनरशिप कम्युनिटी नहीं है, लेकिन डिस्ट्रीब्यूशन ऑफ रिसोर्सेज शुड बी नॉट इक्वल. एब्सोल्यूट इक्वालिटी वर्सेस इक्विटी. इक्विटी इज डिपेंडिंग अपॉन द रिच एंड द पुअर यू डिस्ट्रीब्यूट. समझ में आया? Have you got it or not? Okay, so that is about socialistic principles. Basically, socialistic principles are there in 39B and C. Yes, now let's discuss that is directive principle of state policy. Okay, the first important point is these are, I'll assume something that कि जो हमने जो डिस्कस किया है, okay, उससे मतलब थोड़ा सा ब्रीफली कर लेता हूँ, नॉट वेरी डिटेल. फर्स्ट इज वेरी दैट इज नॉन justiciable. That is the single most important point. This is part 4. Part 4 and article 36 to 51. Yes, 36 to 51. So article 36, पहले 3-4 आर्टिकल डिस्कस कर रहा हूँ, बाकी फिर मैं बता दूंगा आपको, आपको याद करने पड़ेंगे. 36 इज अबाउट डेफिनेशन ऑफ स्टेट. सो ये हमने ऑलरेडी डिस्कस की थी. कहाँ पे? आर्टिकल 12. सो सिमिलर डेफिनेशन, दैट इज पार्लियामेंट एंड एग्जीक्यूटिव, यस, स्टेट लेजिस्लेचर एंड एग्जीक्यूटिव, लोकल बॉडीज एंड अदर बॉडीज. आर्टिकल 36. Article 37 is the most important one because it distinguishes from fundamental rights. अगर आपको डायरेक्टिव प्रिंसिपल का नेचर पता करना है तो आर्टिकल 37 इज मोस्ट इंपॉर्टेंट. नेचर में ये लिखा गया है, दैट इज व्हाट? दैट इज दे आर नॉन जस्टिसिएबल. रिमेंबर दिस. बट यहाँ पे इसका इंपॉर्टेंस नहीं है ये भी बताया दिया है, लेकिन इसका इंपॉर्टेंस ये भी क्या है बता दिया. बट दे आर, यस, दे आर फंडामेंटल, बट दे आर फंडामेंटल टू द गवर्नेंस. ये एक बार आया था वर्ड, दैट इज फंडामेंटल टू द गवर्नेंस ऑफ स्टेट. इज fundamental to governance of state is fundamental rights, directive principles of state policy, DPSP, preamble and duties, और फिर 1 2 3 1 2 1 2 यहाँ था. लोगों को तो पहले तो ये था कि फंडामेंटल वर्ड इतना ही लिखा था, Okay, which one of the following is fundamental to the governance of, yes, which one of the following as per the constitution is fundamental to the governance of India? तो लोगों को कंफ्यूज हुआ डीपीएसपी करूं या नहीं, डीपीएसपी तो पहले काट दिया, फंडामेंटल वर्ड नहीं है। तो ऐसे सिचुएशन है कि फंडामेंटल राइट्स नहीं है। द क्वेश्चन वाज एज पर द कॉन्स्टिट्यूशन, और ये कैच फ्रेज वैसे के वैसे लिया था कॉन्स्टिट्यूशन का कि विच आर फंडामेंटल टू द गवर्नेंस ऑफ स्टेट। सो इट इज अ डायरेक्टिव प्रिंसिपल्स, directive principle, all directive principles. So these are non-justiciable, but nonetheless they are fundamental to the governance. So 36 established definition of state, 37 established nature of all the DPSPs. What is their nature? They are not justiciable. What is their nature? They are fundamental to governance. Article 38. Article 38 is broadly objective. यहाँ पे तो nature पता चला कि क्या है, वो justiciable है या नहीं है। Article 38 is broadly talking about all the DPSPs regarding what is the objective, what is broader objective of all the DPSP. What is the broader objective? There are two things here. Yes, basically it is creating the justice that is, yes, social, economic and political justice. And second clause एक add कर दिया गया. In fact, this clause has added later on. Okay, this clause has added in the, I think in the 44th Constitutional Amendment Act में add किया गया था. The what has been added, that is there will inequality, that is bridging the inequality. I am just talking about, okay, reducing the inequality. Reducing the inequality of the status and the opportunity and different kinds of equality. Again, यहाँ पे कोई specific बात नहीं कर रहा है, देखो. Very broadly, they are establishing the objective that directive principle are there to establish justice and to reduce the inequalities. That is Article 38. Now, Article 39 is, ये जो objective है, उसी objective को थोड़ा सा specific तरीके से बताया है. Okay, there are some six principles, six so-called social principles to be followed while making the policies. Okay, some specific 6 principles to be followed while making the principles. इसमें से B and C अभी जो देख लिए थे. A क्या है? What is A? That is everybody will have the so क्या बोलते हैं? Employment. हाँ, minimum livelihood. Yes, minimum livelihood. Everybody will have the livelihood. B क्या था? अभी बताया था. There will be yes, distribution, equitable distribution of material resources. इसी को थोड़ा सा निगेटिव में बता दिया जाए तो नो कॉन्सेंट्रेशन ऑफ, यस, वेल्थ और प्रॉपर्टी. जैनिस्ट प्रिंसिपल भी है एक, अपरिग्रह, वेल्थ और प्रॉपर्टी है या नहीं है, पढ़ा है जैनिज्म. नो कॉन्सेंट्रेशन, अपरिग्रह, अस्थेय, brahmacharya, satya and ahimsa, 5 precepts of Jainism. Anyways, so 39B and C, that is equitable distribution of material resources and no concentration of property. D is equal pay for equal work for men and women. ठीक है. E is related with the health and the strength of worker and children. Okay, will not be hampered in case of work. मतलब protection of health and strength of worker and children. This is basically against the exploitation. Are you understanding? This has to be read. In fact, जो 23rd article है, 23rd and 24th they say has to be read with E and F, because 24th and 23 में क्या है, 23 and 24 में ending the exploitation, and 24 is ending the exploitation in the hazardous industry. So it is the same. The health and the strength of the worker and the child, okay, will not be hampered. And second, F is there should be promotion. There should be promotion for the healthy development of child. Healthy development of child. So you can remember this clubbing this two. यहाँ पे minimum livelihood रहेगा तो उनका payment हो जाएगा, ठीक है. 9 this B and C तो you can remember, and this two you can remember this way. Understood? Somebody will work के लिए pay मिलेगा. Minimum work, equal pay, distribution and no concentration of property, and both are for the protection of worker and child, and this is for the promotion of health of the child. So this is 39. Now let us come here. 37 establish nature of DPSP, 38 establish broader objective of DPSP, 39 establishes different principles of DPSP. Now here onward 40 say what are all specific चालू हो जाते हैं. That is 40 to yes 51. So you have to remember that. I am not going to repeat it. I'll ask you tomorrow. Okay, I can tell you अभी बोलूँ या कर लोगे आप. See, let's see that आपको भी अगर आता है तो 40 क्या है? 40 पंचायत. Okay, that is about the organization of panchayat. 41 is right to work, right to education, and right to public assistance in case of yes old age वगैरह. Okay, right to work, right to education, and right to public assistance. That is a 41. 42 is that is yes living. Yes, pay for the नहीं maternity yes that is there in case that is a condition for the humane condition. Okay, humane condition for the workers and the maternity relief. नहीं living wage just in human condition and the maternity relief, maternity condition. Okay, then that वो लिविंग वेज उसी में राइट टू वर्क वाला जो हो गया ना 43 में आ जाएगा वो. सी फर्स्ट इज राइट टू वर्क, सेकेंड इज जस्ट इन ह्यूमन कंडीशन एंड मैटरनिटी रिलीफ, थर्ड इज दैट इज 43 इज दैट इज अ लिविंग वेज. लिविंग वेज इज डिफरेंट फ्रॉम मिनिमम वेज. ओके, मिनिमम वेज इज जस्ट थ्रो अवे प्राइस, लिविंग वेज इज some good compensation. Okay, so living wage is a 43. 43A is there, then management of industry. Okay, 44 is yes uniform civil code. 40 and 44 तो ऐसे ही flat याद रखो. Okay, 40 is panchayat, 44 is uniform civil code. 45 you have to remember from 86 constitution. Okay, जो child and वाला 0 to 6, that is education and the their childhood care. 46 is related with the agricultural and animal husbandry, should be formed on the scientific basis. 46 is agricultural and animal husbandry. कॉटेज वो उसी में है, नहीं आ रहा हूँ मैं उसके ऊपर. 47 is related with the health. Related with the health क्या है? Increasing the nutritional status, intoxication and in this thing, and promotion of public health. That is a 47. 48 is monuments. 48 है ना monuments. नहीं, 48 is environment. 48 is A is environment. 48 क्या है देख लो, इंडस्ट्री है शायद ये. नहीं, एनिमल हस्बेंड्री वाला इज 47. नहीं 48 एनिमल हस्बेंड्री वाला. Slaughtering of cows and something more is there. Milch animal. Okay, that is 48. 49 is monuments. 49 is monuments. 50 is a separation of executive from the judiciary. 51A is international relations. नहीं sorry 51. peace treaty वगैरह. ठीक है, one कीवर्ड याद रखो. 48 is exclusively that cow slaughter, milch and all those things. ठीक है. So this is yes what is to be remember generally. ये तो याद ही कर लो आप, मैं अंदर कभी पूछता रहूँगा या नेक्स्ट क्लास में पूछूंगा. अमेंडमेंट्स वाले 4 याद रखते हैं. हाउ मेनी टाइम्स अमेंडमेंट हैज हैपेंड? 3 और 4 ऐसे आंसर दोगे पीटी में. प्रीलिम्स में 3 और 4 कैसे रहेगा वहां पे ऑप्शन? 4 times. It's a 4 times. One is 42nd. 42nd में कितने ऐड हुए? 4. ओके, उसमें से ये एक ऐड हुआ है F. ओके, 39 में F क्लॉज जो है ये ऐड हुआ है. देन 39A फ्री एंड लीगल एड. 43A that is management of industry. That is management of participation of worker in the management of industry. 48A environment. ओके, कितने 4 हो गए ना? 39A, 43A, 48A and this 39F. This is 42nd amendment. Then 44th amendment ये सेकंड वाला ऐड किया था. जस्टिस पहले सोशल इकोनॉमिक ये जस्टिस लिखा था बाद में और थोड़ा सा ब्रॉड कर दिया. 44. दिस इज द सेकंड टाइम हैज हैपेंड. थर्ड टाइम 86th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट, उससे 44 की लैंग्वेज चेंज कर दी गई. हाँ, 45 की लैंग्वेज चेंज कर दी गई. एंड लास्ट इज यस इंपॉर्टेंट वन, 97 दैट इज कोऑपरेटिव्स. वहाँ पे फंडामेंटल राइट भी चेंज हुआ है. कहाँ पे चेंज हुआ है फंडामेंटल राइट? हाँ, ट्रेड इन एसोसिएशन 19 में क्लॉज 3, 19 क्लॉज 1, हाँ, एंड क्लॉज 3 और C. अंडरस्टूड. तो यहाँ पे कहाँ चेंज हुआ है? कोऑपरेटिव्स कहाँ लिखा था? हाँ, कॉटेज इंडस्ट्री. सो कौन सा आर्टिकल है वो? यस, 43. ठीक है, ट्रेड यूनियन एंड कॉटेज. That is the cooperatives. The word cooperatives has been added. So this is the 4th time the constitution has been amended. Okay, and now that's it about the. नहीं अभी नहीं है. Fundamental duties एक दो line. Fundamental duties were not present originally. They have been added through 42nd Constitutional Amendment Act. ठीक है. 10 fundamental duties were originally there. It is by the recommendation of Swaran Singh Committee and it has been amended once. ये 4 ही point याद रखो. First is not present in original constitution, added by the 42nd Constitutional Amendment Act on the recommendation of Swaran Singh Committee. Originally there were 10 and 11 that has been added by the 86th Constitutional Amendment Act, that is 51A clause K. K से वो चिल्ड्रन का 0 to 6 नहीं 0 to 6 नहीं 6 to 14 पेरेंट्स को. बाकी जो फंडामेंटल ड्यूटीज है आप याद करके आओ, मैं आपको अंदर अंदर पूछता रहूँगा. सेकेंड इज इम्पॉर्टेंट वन. कभी क्वेश्चन पूछा जाता है कि स्वरण सिंह के 3 रिकमेंडेशन उन्होंने नहीं लिए थे. हाँ, वन इज द टैक्सेस, that is payment of taxes. They have suggested should be the duty but is not a part of fundamental duty. Punishment, like parliament may by law, okay, can make a provision for the punishment for violation of fundamental duties. और एक कौन सा रह गया? Taxation. दो ही है क्या? नहीं, 12 सजेशन थे और एक कुछ पॉइंट है. एनीवे, सो दैट्स 2 important aspect. One is related with the taxation and one is related with the punishment. Okay, now you have to take a short test. हाँ, टेस्ट है, very fast. Can now just leave it as you are there. All the answers and explanations. Answer sheet मिला है क्या आपको? ठीक है, आंसर शीट मिल जाएगा. आई एम गोइंग टू डिस्कस 3-4 क्वेश्चंस ओनली. ओके, सो दैट इट्स ऑलरेडी रनिंग आउट ऑफ टाइम. तो मैंने कुछ मतलब नोट्स भी कर लो उसको, कुछ एक एडिशनल पॉइंट्स है. अदरवाइज आंसर्स एंड एक्सप्लेनेशंस आर अवेलेबल. इफ एनीबडी हैज़ एनी प्रॉब्लम वी कैन अगेन डिस्कस. दैट्स नॉट एन इशू. सी आई लास्ट रैंडम. फर्स्ट का क्या है? C 1, 2 and 4. There is a lack of political will also. Okay. Yes. Anyways, I feel that such kind of subjective questions and ambiguous generally are not asked. Okay, यहाँ पे put up किया है, but do not worry about it. Yes, in that regard you are right. तो 1, 2, 3, 4 भी आ सकता है. ठीक है. इसलिए मैंने वो पूछा था. देन कम टू फिफ्थ क्वेश्चन का क्या किया आपने? ए, यस, बिकॉज द इनुमरेटेड 11 फंडामेंटल ड्यूटीज, वहां पे क्या लिखा हुआ था? एट दैट टाइम पूछा है, ठीक है. एट दैट टाइम हाउ मेनी देयर? 10. ओके, सो शुड नॉट बी. सिक्स पे आ जाइए. सिक्स पर क्या किया है? सिक्स का एक्चुअली इट इज, यस, एनीवन? डी है. सो द इंस्पिरेशन, दो चीजें याद रखो. डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी आर इंस्पायर्ड बाय रशिया. बेसिकली इट वाज रशियाज इंस्पिरेशन है, लेकिन आयरलैंड, सॉरी सॉरी, आयरलैंड, आयरलैंड, ओके, इट हैज बीन इंस्पायर्ड बाय आयरलैंड. बट जो मेंशन किए हुए हैं जो डायरेक्टिव प्रिंसिपल्स, इट वाज ऑन द लाइन ऑफ 1935 एक्ट. 1935 एक्ट के अंदर जो डायरेक्टिव प्रिंसिपल्स अभी जो हम कहते हैं, दीज वेर डायरेक्टिव प्रिंसिपल्स फॉर द गवर्नर इन द फॉर्म ऑफ instruction issues to the governor and governor of India. So remember two things for the source of inspiration for directive principle. अगर source of inspiration पूछा जाए तो it's the Ireland, and it is on the lines of instructions that have been given to governor. Something similar to preamble. Preamble is inspired by US. ओके, बट इट इज ऑन द लाइंस ऑफ ऑब्जेक्टिव रेजोल्यूशन, मतलब जो है ऑब्जेक्टिव रेजोल्यूशन जो ड्राफ्ट किया हुआ था. फंडामेंटल ड्यूटीज आर इंस्पायर्ड बाय, दैट इज बाय रशिया. ओके, फंडामेंटल ड्यूटीज आर इंस्पायर्ड बाय रशिया. ओके, जस्ट रिमेंबर दैट. ओके, सो दैट्स, यू विल सी बाकी के आंसर्स तो कर लेना. सेवंथ, 1 minute, imposes a duty on a state to give a direction. Yes, it's a, don't, no, so duty, see, it is a duty, non justiciable duty है वो. हाँ, नहीं नहीं, वो don't go into that much of nuances. ये एक मतलब बहुत ज़्यादा पढ़ाई का वो रहता है. Do not go into that much of detail. You are right, मतलब वो जो है, but it is a duty for them. You can call that duty as a non justiciable. What's the problem in saying that? ठीक है, understood? ठीक है. सेवन इज सी, यस. पहला क्या है? दैट इज दे आर अप्लीकेबल टू ऑल रेसिडेंट्स. क्या होना चाहिए वहां पे? दे आर अप्लीकेबल टू सिटीजन. रेसिडेंट्स में फॉरेनर्स भी आ सकते हैं. ओके, सो दैट्स, जस्ट रिमेंबर दैट. देन एट, एट का आंसर है बी है. सी द क्वेश्चन, इफ यू हैव नॉट रीड देन यू आर मेकिंग द मिस्टेक. नहीं, sorry, 8 का, see the thing is that not, see, there are certain directive principles which are given in part 4 and there are certain directives which are not part of part 4. तो नहीं, we'll see one by one. Every state will provide adequate facilities for the instruction in the mother tongue. ये नहीं है, part 4 में नहीं है. This is not in the part 4. Not included in part 4, so that is correct. That is yes answer है उसका. ठीक है, 1 is right. Then union should promote the spread of Hindi language. It is also right. It is not a part of 4. Okay. To bring the prohibition of intoxicant, yes, it is a part, so it is wrong. And claim of SC and ST is taken into consideration for making, no. They claim ये 340 का है. These are the three, in fact. हाँ, 335 का है. हाँ, तो यस आ जाएगा. हाँ, इनफैक्ट दीज आर द थ्री, रिमेंबर अदरवाइज ऑल्सो, दीज आर द थ्री डायरेक्टिव प्रिंसिपल्स विच आर डायरेक्टिव प्रिंसिपल्स बट नॉट अ पार्ट ऑफ यस पार्ट 4. तो इसके आर्टिकल क्या है एक बार लिख लो. द स्टेट विल प्रोवाइड द एडिक्वेट फैसिलिटीज फॉर इंस्ट्रक्शन. प्राइमरी 350A, देन 350 हिंदी वाला. रिमेंबर दैट हिंदी प्रमोशन जो है यूनियन की ड्यूटी है, एंड प्राइमरी एजुकेशन इम्पार्टिंग जो है वो स्टेट एंड लोकल की रिस्पॉन्सिबिलिटी है. ठीक है, सो आंसर इसका क्या आ जाएगा फिर? हाँ, 3 इज नॉट देयर, तो बी आंसर. ठीक है. देन कम टू यस क्वेश्चन नंबर 10. एक कहीं पे नोट कर लो, ये परमानेंटली याद ही करके रखो. ठीक है. द फंडामेंटल राइट्स विच आर अवेलेबल ओनली फॉर इंडियन सिटीजन्स, लिख लो। 5 ही फंडामेंटल राइट्स है। फंडामेंटल राइट्स कहीं अच्छी जगह लिख लो, ऐसे कागज वागज पे, मतलब जो रहेगा नहीं, नोटबुक में लिख लो या फिर याद ही करो इसको। ओके इसको कोई ऐसे लॉजिक, मतलब लॉजिकली कर के भी याद करो, एक रट्टा मार के भी याद करो, ठीक है। यस, सो 15, 16, 19, 22 का हाफ आई विल एक्सप्लेन, ठीक है। 22 का हाफ, 29 एंड 30, रट्टा मारो जिंदाबाद। 15, 16, 29, 30 पहले दो और आखिरी दो, फिर 19 एंड 22। 22 का हाफ क्या है? यस, इट इज लाइक वन इज ऑर्डिनरी लॉ का डिटेंशन है और एक है प्रिवेंटिव डिटेंशन। द विच वन इज अवेलेबल ओनली फॉर द पर्सन? प्रिवेंटिव डिटेंशन नहीं, नॉर्मल वाला ओनली फॉर इंडियंस एंड प्रिवेंटिव डिटेंशन इज फॉर बोथ। ओके, सो बोथ वाला नहीं कर रहे हम यहाँ पे, हम क्या कर रहे हैं? ओनली इंडियंस के लिए, ओनली इंडियंस के लिए पहला हाफ दैट इज अ प्रिवेंटिव डिटेंशन अंडर ऑर्डिनरी लॉ, राइट्स गिवन टू द पर्सन, सॉरी प्रिवेंटिव डिटेंशन, राइट गिवन टू द पर्सन फॉर द डिटेंशन अंडर ऑर्डिनरी लॉ। सो 15, 15, 16, 19, 20 का फर्स्ट पार्ट, 29 एंड 30, इसको याद रखो, दिस इज फॉर इंडिया। तो इसका उल्टा करोगे तो विच इज अवेलेबल फॉर बोथ। ओके, हाँ, ऑल। तो इस हिसाब से ये आंसर आ जाएगा। तो इसका आंसर क्या है? 10 का 1, 2, 3, 4, 5, 6, हाँ 6 मतलब 5.5 है, समझो। हाँ, इसका आंसर है सी। इवन राइट टू एजुकेशन, ये जो 21 है, दे अवेलेबल टू ऑल। ओके, ये याद कर लो। तो इसी बेसिस के ऊपर 14 भी सॉल्व हो जाएगा, क्वेश्चन नंबर 14। अब वो याद किया तो सभी आ जाएंगे वो, जस्ट रिमेंबर दिस, समवेयर नोट इट डाउन। नाउ कम टू 19। 19 में एक लक्ष्मीकांत में क्लासिफिकेशन दिया है, दैट इज इंटेलेक्चुअल, जो डीपीएसपी के क्लासिफिकेशन दिया है, गांधीयन, लिबरल, इंटेलेक्चुअल एंड सोशलिस्ट, वो एक बार देख लो, ठीक है। तो उसी के ऊपर है, आई एम नॉट गोइंग टू डिस्कस नाउ, जस्ट यू विल सी इट, आंसर्स दिए हुए हैं ऑलरेडी, ठीक है। देन कम टू 20, कम टू 20। यस, इसका आंसर क्या है? बी। यस, यस, एनी अदर आंसर? यस, अभी तो एक ने बताया था, एम्बिट ऑफ आर्टिकल 21 हैज बीन एक्सपांडेड, राइट टू लाइफ एंड लिबर्टी का 21 में था या नहीं था? एक इन्होंने बताया था कि इन्होंने एनवायरमेंट, उसमें 3 लिखे थे हमने, क्लीन एनवायरमेंट, क्लीन एयर एंड क्लीन वाटर। ओके, डायरेक्टिव प्रिंसिपल, it's a directly here environment related, that is 48A, and fundamental duty, yes, one of the duties they say there, that is a wildlife, forest, river and lake, उससे एक है। फंडामेंटल राइट कहाँ है यहाँ पे? 21A एक्सपांशन, ठीक है, राइट टू लाइफ का एक्सपांशन है। यस, 21 is yes, only A. See, why B not there? Yes, it is 44. Do not make this mistake. राइट टू प्रॉपर्टी के कई बार ये राइट टू प्रॉपर्टी को मिस्टेक हो जाती है। 42nd नहीं है, 44 है। और ये जो मैंने यहाँ पे बताया था, ये जो क्लॉज ऐड हुआ था, 2 क्लॉज ऐड किए थे, नहीं क्लॉज नहीं, ये जो 39B and C है, 39B and C has been added by 25th, but it has been extended to all the DPSP by 42nd, but later on it was struck down, but 42nd has made that attempt. Are you following me? Answer is neither. No, answer is A. It has, I'll explain. We will come to 31C. No, don't take that way. नहीं, made fundamental rights बोला है उन्होंने। नो, हाँ, ये यस, एज अ प्रिंसिपल बोल रहा है। हाँ, अगर वो सिलॉजिज्म वाला देखोगे, व्हेन क्वांटिफिकेशन इज नॉट मेंशन, पॉलिटिशियन आर करप्ट, तो इसका मतलब रहता है ऑल पॉलिटिशियन आर करप्ट, सिलॉजिज्म वाइज, बट नहीं है, मतलब वही है थोड़ा सा किया है सिलोजिज्म में, पता है नहीं पता है? व्हेन क्वांटिफायर इज नॉट देयर इट इज अ यूनिवर्सल क्वांटिफायर सिलोजिज्म में। बट थोड़ा सा कभी कभी है ना, तो एक सेंस ऑफ क्वेश्चंस भी देखना रहता है। यू आर राइट, मतलब दैट एकदम अगर टेक्निकली जाए। यस, कम टू 24। आई होप नोबडी हैज मेड मिस्टेक हियर, या somebody has still 25th 25th, yes। हाँ, which one of the following is incorrect? So last is correct, third is correct। See, 44th constitutional amendment act नहीं है, कौन सा है? हाँ, it has been not in, which is in force now बोल रहा है वो, अभी बोला था मैंने। Although the 44th has changed from 3 months to 2 months, but it has not in force। ठीक है, तो वो स्टेटमेंट नहीं करेक्ट है, हाफ करेक्ट है, एंड का नहीं करेक्ट है। और ऊपर क्या लिखा हुआ है? यस, ये उल्टा है इसका, ए का। दैट इज ऑर्डिनरी लॉ में केवल सिटीजन को है, एंड सेकंड पार्ट में प्रिवेंटिव डिटेंशन इज फॉर बोथ, बट यहाँ पे रिवर्स किया है उन्होंने। ठीक है, जो अभी बोला था। सो व्हाट आर द राइट्स विच आर एक्सक्लूसिवली फॉर द सिटीजन्स? यस, 15, 16, 19, 22 का हाफ, 29, 30। ओके, उसको याद कर लो। द लास्ट क्वेश्चन, वेलफेयर स्टेट। डी कैसे आ जाएगा? फंडामेंटल ड्यूटीज, वेलफेयर स्टेट, वो कैसे करेंगे? अरे वो ड्यूटी, अब वेलफेयर स्टेट मतलब क्या हो गया? नहीं, फंडामेंटल ड्यूटीज आर फॉर सिटीजन्स। व्हाई इट इज फॉर द स्टेट व्हेन दे आर ऑलरेडी देयर? नो, इट इज ओनली 1 and 3। It is C। Do not say that only. Welfare state is a very broad term. It is not just directive principles. Okay. Yes, affirmative actions are so many. You can see, you have to take एक तो पहले आंसर शीट दी जाएगी, उसको क्रॉस चेक कर लो, एक्सप्लेनेशन देखो। इफ एनी प्रॉब्लम इज देयर, जॉट इट डाउन, वी विल डिस्कस इन द नेक्स्ट क्लास। दैट इज फर्स्ट थिंग। सेकेंड थिंग, यू विल बी गिवन असाइनमेंट्स ऑफ 24 मोर क्वेश्चंस। वो आप आराम से, मतलब एट यूर लीजर सॉल्व करो। उसके साथ आंसर शीट भी दी जाएगी, उसको बाद में चेक करो आंसर शीट से, नहीं तो पहले आंसर पढ़ के। ठीक है, सो प्लीज डिस्ट्रीब्यूट। थैंक यू सो मच। ओके, हाँ, कल पार्लियामेंट वी आर गोइंग टू स्टार्ट लेजिस्लेचर, सो थोड़ा सा पढ़ के भी आ जाओ। ओके, वी आर गोइंग टू स्टार्ट।